conducted with bias, irrelevant considerations, and procedural violations of the Standing Order 75, 78, and 80, and that the cumulative defects render the entire impeachment null and void. The petitioners adopted and relied on H.E. Gachagua's submissions and the Wambora principles on quasi-judicial impeachment proceedings and identified the following issues for determination: whether the impeachment of the Deputy President met the constitutional threshold of a measure of last resort in light of the availability of alternative constitutional and statutory mechanisms, whether the constitutional framework governing the impeachment of a Deputy President under Article 150, Sub-Article 2 was properly invoked, applied, and distinguished from the regime governing the impeachment of a president under Article 145, whether the Senate complied with the mandatory requirement to apply Articles 144 and 145 with necessary modifications as contemplated under Article 152 and Standing Order 79. Whether the failure to apply the modification rule undermined the constitutional principles of sovereignty of the people, national values, and political rights, including the legitimate expectation of tenure. Whether the impeachment process satisfied the constitutional and jurisprudential standards applicable to quasi-judicial proceedings as articulated in the Wambora decisions. Whether the Senate's failure to comply with constitutional requirements renders the impeachment process null and void. Whether the impeachment process violated the Deputy President's right to equality and equal protection of the law under Article 27. Whether Parliament, in conducting the impeachment proceedings, acted as an impartial and unbiased quasi-judicial body as required by law. Whether the debates and proceedings in both the Senate and the National Assembly were confined to the substantiation of the charges or were contaminated by irrelevant, extraneous, and prejudicial considerations. Whether the refusal to grant an adjournment upon the Deputy President falling ill violated his right to a fair hearing under Article 50, including the right to be present and to be adequately present, to adequately present his defense. Whether the Senate misapplied Standing Order 78 by proceeding under a plenary hearing without affording procedural safeguards and by improperly treating the proceedings as time-bound. Whether the impeachment proceedings violated the Deputy President's right to adequate time and facilities to prepare a defense under Article 50, Sub-Article 2A, and the right to be heard under Standing Order 80. Whether the Senate acted in violation of its own standing orders, including Standing Orders 75, 78, and 80, and the legal effect of such violations. Whether sufficient time existed within the constitutional and procedural framework to accommodate adjournment and ensure a fair hearing, and whether failure to utilize such time rendered the process unconstitutional. Whether the continuation of proceedings in light of the Deputy President's illness violated his fundamental rights to life, dignity, health, and access to justice under Articles 26, 28, 48, and the state obligations under Articles 10, 19, 20, and 21. And finally, what reliefs are available where a constitutional process is found to be procedurally and substantively defective. Learned counsel submitted that impeachment is not intended to be a primary or convenient mechanism for addressing alleged misconduct, but rather an extraordinary remedy reserved for the clearest and most compelling cases where no other lawful avenue exists. They argued that the Constitution establishes a graduated hierarchy of accountability, beginning with civil liability, criminal prosecution, and administrative action, and only thereafter impeachment. It was emphasized that Article 143 expressly removes immunity from civil and criminal proceedings for the Deputy President, unlike the President. According to Mr. Ndegwa, this signals that allegations against the Deputy President should, in the first instance, be addressed through ordinary legal processes. Parliament, however, bypassed these mechanisms and resorted to impeachment as a first recourse, which counsel contended offends the principles of proportionality, rationality, and legality. They further submitted that no evidence exists that Parliament considered whether the allegations could have been addressed through criminal investigation or civil proceedings before invoking impeachment. Counsel also drew attention to Article 152, which provides that Articles 144 and 145 apply to the Deputy President with the necessary modification. Counsel argued that this phrase is not ornamental, but a deliberate constitutional command requiring contextual adaptation of the presidential impeachment framework to the distinct office of the Deputy President. In their view, the requirement imposes an active obligation on the Senate to interrogate, adjust, and tailor the procedure rather than merely transplant it without reflection. Standing Order 79, they submitted, operationalizes this obligation by requiring the Senate to consciously and expressly apply the modification principle. Mr. Ndegwa submitted that nowhere in the Senate Hansard is the Speaker recorded as guiding the House on the necessity, the scope or content of the required modifications as the Senate proceeded, as though Article 145 applied mutatis mutandis and in toto without any modification. He stated that this failure is not merely procedural but a substantive and jurisdictional issue which renders the entire process unconstitutionally defective ab initio. The petitioner submitted that this modification requirement ensures that impeachment is not invoked where alternative legal mechanisms such as the courts, EACC, or DCI are adequate. It was their case that the failure to modify denied the Deputy President the procedural safeguards that would have arisen from a properly tailored process, including consideration of alternative accountability mechanisms, flexibility in procedure to ensure fairness, and enhanced scrutiny of the necessary and proportionality of the impeachment. It was their submission that the office of Deputy President derives its legitimacy from the sovereign will of the people expressed at the ballot under Article 1, and impeachment without proper modification undermines this sovereign will and defeats the legitimate expectation of tenure for both the office holder and the electorate. That Article 38 guarantees citizens the right to elect leaders and to have them serve their full term, subject only to lawful and constitutionally compliant removal process, and that the failure to modify the process resulted in an unjustified interruption of the people's sovereign mandate. Mr. Ndegwa submitted that the Deputy President fell ill during the proceedings while actively engaged in his defense, and that this is not disputed and is recorded in the Senate Hansard. that the Senate refused to grant an adjournment, proceeding instead to a conclusion in his absence, and he submitted that this violated Article 52 on the right to adequate time and facilities to prepare a defense, and Article 52F on the right to be present when being tried, and Standing Order 80 on the right to be heard within Senate proceedings. That a hearing conducted in the absence of the principal defense participant due to verified illness cannot satisfy the conditional threshold of fairness. He stated that the Senate had sufficient procedural latitude under Standing Order 75 2B to adjourn without violating any constitutional timeline, but the refusal was not dictated by lack of time, but by a failure to exercise discretion fairly. The petitioner submitted that under Article 26 on the right to life, the state must refrain from actions that undermine physical well-being or exacerbate medical vulnerability, and that proceeding with impeachment during illness reduce the deputy president to a procedural object rather than a rights-bearing participant. They stated that Article 48 on the access to justice extends to all adjudicative processes, including parliamentary impeachment, and that meaningful participation requires reasonable accommodation and denial of adjournment and denial of an adjournment rendered access to justice illusory. They also submitted that the test for bias is objective, and whether a reasonable and informed observer would apprehend bias, and that senators acknowledged imperfections in the case but still voted to impeach, which demonstrated bias. They urged the court to address the impeachment process as a whole, not in fragments, noting that the petitioners have demonstrated cumulative defects, including failure to apply the modification rule under 152, absence of impartiality and presence of bias, reliance on irrelevant and extraneous considerations, violations of fair hearing rights, misconstruction of the constitutional and procedural framework, and breach of Standing Order 75, 78, and 80. They submitted that individually, each defect is serious, and collectively, they reveal a process that is constitutionally unsound from inception to conclusion. That Article 165 3D Roman 2 vests the High Court with jurisdiction to determine whether anything done under constitutional authority is inconsistent with or in contravention of the Constitution. They contended that this court is not being invited to interfere with parliamentary politics, but is being invited to perform its core constitutional function as guardian of legality and fundamental rights, and where Parliament acts within constitutional bounds, the court defers. But where it acts outside those bounds, the court must intervene, not as an intruder, but as a constitutional necessity. As such, the petitioners urged the court to find that impeachment was not a measure of last resort when ordinary legal mechanisms were available and bypassed, that the Senate failed to apply the mandatory modification rule under Article 152, rendering the process unconstitutional ab initio, that the refusal to adjourn during illness violated Articles 50, 26, 28, and 48, that the proceedings were infected with bias and irrelevant considerations, and that the cumulative defects render the impeachment null, void, and of no legal effect. They then prayed that their petition be allowed in entirety.
I will then take over from the 51st petitioner's case. Caroline Wambui Mwangi, the 51st petitioner, in the consolidated petitions, filed the petition dated 26th of September 2024, before the High Court of Kenya at Milimani as a public-spirited Kenyan citizen and a defender of the Constitution. Ms. Mwangi contended that the impeachment process was unconstitutional, unlawful, and politically motivated. She relied on public statements allegedly made by Honorable Didmas Baraza and Honorable Gladys Posholei in September 2024, indicating that the impeachment of H.E. Gachagua had already been predetermined, and further referred to a motion by Honorable Danson Mungatana expressing displeasure with the conduct of His Excellency Gachagua. Ms. Mwangi asserted that the allegations leveled against his H.E. Gachagua were vague and supported by evidence and lacking in specificity and peculiarity, contrary to the constitutional requirements of fair hearing and due process under Articles 47 and 50 of the Constitution. She further alleged that the intended impeachment process mounted to a political witch hunt designed to settle political scores rather than a lawful constitutional process, and contended that the respondents had violated the national values and principles under Article 10, including the rule of law, transparency, accountability, equality, and protection of human rights. She maintained that His Excellency Gachagua had not been accorded adequate notice of the charges against him, sufficient particulars of the allegations, nor an opportunity to adduce and challenge evidence in violation of Articles 25C, 35, 47, and 50 of the Constitution. As such, she sought for the following orders. A declaration that within the purview of Articles 25C, 35, 47, and 50 of the Constitution of Kenya, a person facing impeachment proceedings under Article 150 is entitled to be informed substantially with peculiarity and specificity, and supported with evidence the grounds of impeachment before the commencement of the impeachment proceedings by the National Assembly and Senate. B, conservatory orders do issue against the respondents, restraining them from a collection of signatures in support of a motion to impeach His Excellency Rigathi Gachagua, lodging any motion and or carrying on proceedings seeking to impeach the Deputy President of the Republic of Kenya, the interested party herein. See, an order of compensation enshrined and provided for under Article 23A of the Constitution of Kenya, made up of damages as shall be assessed and quantified by the petitioner, general damages, cost of the petition, and any other relief. The 51st petitioner neither filed any written submission nor attended the physical highlighting of submissions. In respect to the 54th petitioner's case, Emmanuel Elijah Otieno was the 54th petitioner in the consolidated petitions. He is an advocate of the High Court of Kenya who filed the petition dated 18th of October 2024, together with a supporting affidavit also challenging the constitutionality and legality of the impeachment and removal from office of His Excellency Gachagua as Deputy President. He stated that instituted proceedings in the public interest pursuant to Articles 3 and 258 of the Constitution, and contended that impeachment process undertaken by the National Assembly and the Senate was procedurally unfair, politically motivated, unconstitutional, and inconsistent with the constitutional principles governing impeachment under Articles 145 and 50 of the Constitution. He maintained that impeachment was a constitutional mechanism intended to promote accountability and good governance, and not a tool for settling political disputes or managing political differences among leaders. He challenged the legality of public participation process and the fairness of the proceedings before the National Assembly and the Senate, and the substantive threshold applied in removing His Excellency Gachagua from office. He contended that the National Assembly failed to conduct meaningful and constitutional compliant public participation as required under Articles 10 and 118 of the Constitution and Section 5 of the Fair Administrative Actions Act. Mr. Otieno stated that the public participation exercise was hurried, inadequate, both quantitatively and qualitatively, and incapable of reflecting the sovereign will of the electorate, given that only about 223,000 persons participated, despite His Excellency Gachagua having been elected together with His Excellency President Ruto by over 7 million voters. He further asserted that the public participation template prepared by National Assembly was biased because it only contained the allegations against His Excellency Gachagua and failed to include his responses, thereby portraying him to the public as guilt before he had been heard. Mr. Otieno additionally stated that the Speaker, Deputy Speaker, and members of National Assembly demonstrated bias from the outset, failed to accord His Excellency Gachagua a fair hearing, and debated the impeachment motion before proper public participation and before considering His Excellency Gachagua's defense. He maintained that no impeachable offense meeting the constitutional threshold of gross violation, gross misconduct, or commission of crimes under national or international law had been substantiated either before the National Assembly or the Senate. He further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged violations of Articles 25C, 47 and 50 of the Constitution relating to the rights of fair hearing and fair administrative action. He sought the following prayers: A declaration, be and is hereby issued that the public participation organized and conducted by the first respondent did not meet the requirements of Articles 118, 1B of the Constitution quantitatively and qualitatively. B, a declaration be and is hereby issued that the first respondent violated seventh respondent right to a fair administrative action under Articles 47 of the Constitution and Section 4 of the Fair Administrative Actions Act. C, a declaration be and is hereby issued that the first respondent violated the right of the seventh respondent under Article 50, Sub-Article 1 of the Constitution 2010. D, a declaration be and is hereby issued that the resolution of the first respondent to impeach the seventh respondent was invalid and null and void. And E, respondent shall bear the cost of the petition. Likewise, the 54th petitioner neither filed any submissions nor attended the physical highlighting of the submissions. Next is consideration of the 55th and 56th petitioner's case. Stephen Mbugua Wanjiru and Gladys Nyambura Gituha jointly filed the petition dated 20th of October 2024, together with the supporting affidavit sworn by Wambugu Wanjohi. They stated that they were public interest litigants and defenders of constitutionalism. They challenged the legality, constitutionality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President of the Republic of Kenya, as well as the subsequent nomination and approval process relating to His Excellency Kindiki as the Deputy President nominee. The petitioners contended that the impeachment process before both the National Assembly and the Senate were marred by procedural irregularities, bias, denial of fair hearing, and unconstitutional conduct, that the Speaker and the Deputy Speaker of the National Assembly had publicly pronounced themselves in favor of the impeachment before presiding over the proceedings, thereby violating the constitutional principles of impartiality, neutrality, and natural justice. The petitioners further challenged the adequacy and constitutionality of the public participation exercise conducted on the 4th and 5th October 2024, asserting that the notice period was too short to permit meaningful participation, that the questionnaires used by the National Assembly only presented the accusations against His Excellency Gachagua without his responses, and that the Parliament failed to avail documentary and electronic evidence to the public to facilitate informed participation. He further asserted that the Senate proceedings contending he further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and that by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged that Sorry, I had repeated that bit, but I'll proceed from paragraph 133. They additionally alleged that public participation process was chaotic, disorderly, and marred by violence and characterized by low turnout in several constituencies and undertaken on days when many Kenyans were engaged in religious worship, thereby undermining the constitutional threshold for meaningful participation under Articles 10 and 118 of the Constitution. The petitioners also challenged the conduct of the Senate proceedings. They contended that the Senate acted in violation of Articles 25C, 47 and 50 of the Constitution by refusing to adjourn the impeachment hearing despite His Excellency Gachagua's illness and hospitalization, and thereby denying him an adequate opportunity to personally defend himself. Further, the petitioners alleged bias and conflict of interest arising from participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Omolo, Senior Counsel, in the Senate proceedings, stating that their roles compromise the fairness and impartiality of the impeachment process. The petitioners maintained that the impeachment proceedings before both houses of parliament were characterized by constitutional violations, procedural inconsistencies, and disregard for due process. The petitioners also challenged the subsequent nomination and approval of His Excellency Kindiki as Deputy President, contending that the nomination was tainted by the same constitutional and procedural violations that affected the impeachment process and was therefore null and void. As such, they sought the following prayers: a declaration that the grounds of impeachment laid in the special motion dated 24th of September 2024 did not meet the constitutional and legal threshold for impeachment of a deputy president. That a declaration do issue that public participation exercise conducted on the 4th and 5th of October was flawed and incapable of meeting the constitutional standards required for such processes, and the outcomes of this flawed participation do not reflect the will of the people and cannot be considered a legitimate basis for advancing the impeachment motion. See, a declaration that the impeachment process against the Deputy President initiated by the National Assembly and subsequently conducted by the Senate was tainted by substantive and procedural constitutional violations, rendering unconstitutional, illegal, null and void. D, an order nullifying the impeachment of the Deputy President as the process was marred by procedural irregularities, bias, conflict of interest, and a violation of the right to a fair hearing as guaranteed under Article 50 of the Constitution. A, an order directing the immediate reinstatement of the Deputy President to his duly elected office, having been unconditional and constitutionally and unlawful removed through an impugned process. F, an injunction restraining the President, the National Assembly, and any other state organs from proceeding with or effecting the appointment of any other person to the office of the Deputy President pending the hearing and determination of this petition. G, an order revoking the nomination and subsequent approval of Professor Kithure Kindiki as Deputy President by the National Assembly, as it stems from an unconstitutional process and is procedurally flawed and in violation of the Constitution. H, a mandatory injunction directing the National Assembly and the Senate to comply with the Articles 10 and 118 of the Constitution by ensuring meaningful and effective public participation in any future impeachment processes or similar proceedings of national importance. I, declaration that the participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Omolo, Senior Counsel, in the impeachment proceedings violated the principles of impartiality and fair hearing and constituted a conflict of interest that compromised the integrity of the impeachment proceedings. J, an order awarding the petitioner cost of this petition, and K, any other orders or reliefs. The 55th and 56th petitioners did not file any written submissions, and they also did not turn up at the hearing. The 57th petitioner was Edwin Gekonge, and he filed the amended petition dated 23rd of October 2024 before the High Court of Kenya at Mombasa, together with their supporting affidavit on of the same date. He stated that he is a law-abiding citizen, human rights defender, and a public-spirited litigant acting in his own interest and in the interest of citizens of the Republic of Kenya. The petition challenged the constitutionality of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President, as well as the subsequent nomination and approval of His Excellency Kindiki as the Deputy president. He stated that the impeachment proceedings before the National Assembly and Senate violated Articles 10, 32, 47, 48, 50, 145, and 150 of the Constitution. He stated that the public participation process conducted on the 4th and 5th October 2024 fell below the constitutional threshold of effective, meaningful, and inclusive public participation. The petitioner asserted that the notice period for the public participation exercise was too short, that the exercise was limited to county offices instead of constituency level, and that the extension of the exercise to 5th of October 2024 was ineffective because the notice was issued on the very day of participation and coincided with a Sabbath day of worship for the Seventh-day Adventists, thereby excluding members of the faith from meaningful participation. He further alleged that the exercise was marred by confusion, violence, inadequate information, early closure of centers, and generally low participation, thus violating Articles 10 and 118 of the Constitution. He also challenged the legality of the Senate proceedings on the ground that His Excellency Gachagua was denied a fair hearing contrary to Article 50 of the Constitution. He contended that although the first petitioner had fallen ill and was unable to continue participating in the proceedings, the Senate declined to adjourn the hearing and proceeded to vote on the impeachment charges in his absence. Mr. Gekonge stated that Article 145 of the Constitution did not prescribe rigid timelines that could override the constitutional right to a fair hearing, and that the Senate failed to apply the necessary constitutional modifications contemplated under Article 150 in impeachment proceedings relating to a deputy president. He further maintained that the evidence presented before the Senate did not attain the constitutional threshold required to establish gross violation of the Constitution, gross misconduct, and serious reasons to believe that His Excellency Gachagua has committed crimes under national law. Mr. Gekonge also challenged the legality and constitutionality of the nomination and approval of His Excellency Kindiki as Deputy President, stating that the constitutional timelines under Article 149 contemplated meaningful public participation and adequate vetting before approval of a Deputy President nominee. He contended that His Excellency Kindiki remained a state officer serving as Cabinet Secretary at the time of nomination and had not formally resigned, thereby rendering him constitutionally disqualified under Article 137 and Sections 23 and 24 of the Elections Act. The petitioner further challenged the role of IEBC, contending that the commission was not properly constituted and therefore incapable of lawfully confirming the qualifications of the nominee. Mr. Gekonge sought the following orders. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th and 5th October 2024 regarding the special motion fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the public participation process on the 5th of October 2024 was unconstitutional for failure to provide sufficient notice and in violation of the freedom of religion under Article 32. C, a declaration that the impeachment process against the first interested party undertaken by the first and the second respondents was unconstitutional and did not meet the requirements set under Articles 145 and 150 of the Constitution of Kenya. D, a declaration that the impeachment process as against the first interested party undertaken by the first and the third respondents was unconstitutional as it violated Article 50 of the Constitution of Kenya in terms of providing a fair hearing. E, a declaration that the impeachment proceedings of the first interested party taken by the first and third respondent was unconstitutional, void for failing to meet the evidential threshold of the impeachment of a deputy president under Article 150, subarticle 1B. F, a declaration that the nomination of Abraham Kithure Kindiki by the President of Kenya is unconstitutional, null and void, and in contravention of Article 137(1) of the Constitution. G, a declaration that the approval of the nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional for failure to comply with Articles 10 and 118 of the Constitution. H, a declaration that the approval of the nomination of a deputy president by the National Assembly under Article 149 of the Constitution must include public participation in every constituency. I, a declaration that the approval and nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional, as Abraham Kithure Kindiki had not resigned as a state officer. J, a declaration that the independent, that IEBC, at the time of nomination of Abraham Kithure Kindiki, was not properly constituted to approve or confirm the qualification of Abraham Kithure Kindiki under Article 137(1) of the Constitution. K, a declaration that IEBC had violated Article 149 of the Constitution by confirming that Abraham Kithure Kindiki was qualified to stand as a member of Parliament as per Article 137(1) of the Constitution. L, any other orders as the court may deem just. Mr. Gikonge likewise did not file any submissions. In respect of the 50th, the 52nd and the 53rd petitioners, that is John Njomo, Clarence Eboso, and Wanjiru Mwangi, their petitions were withdrawn from the consolidated proceedings on the 7th November 2024, as well as on the 16th of May 2025. On the 7th interested parties case and submission, that is Kituo cha Sheria, it appeared as the 7th interested party in these proceedings and filed a replying affidavit sworn on the 15th of April 2026 by Dr. Wambua Kituku, who is its executive director, as well as written submissions of even debt. Kituo identified 4 issues for court's determination, being whether the National Assembly process met the constitutional threshold for meaningful public participation and Articles 1, 10, and 118 of the Constitution. Secondly, whether impeachment proceedings were quasi-judicial to the extent that they meet constitutional and statutory procedural fairness standards. Thirdly, whether the court could review the procedural regularity of impeachment proceedings consistently with the doctrine of separation of powers. And lastly, whether the refusal to adjourn and the decision to proceed with in absentia violated the first respondent's petitioner's right to fair administrative action and fair hearing under Articles 10, 27, 28, 47, and 50 of the Constitution. Kituo cha Sheria averred that Article 118 of the Constitution mandated Parliament to facilitate public participation and involvement in legislation and all other business of the Assembly and its committees. They further argued that the removal of a deputy president from office was one of the most significant constitutional functions assigned to the National Assembly and the Senate and directly affected the sovereign will of the people. It was their understanding that public participation in such a constitutional process had to be both quantitative to mean that a sufficient number of citizens had to be reached and accorded an opportunity to participate, and qualitative to mean that the participation had to be meaningful and capable of influencing the decision-making process. Kituo further averred that the one-day public participation notice given by the Speaker of National Assembly and the National Assembly itself was inadequate to reach a substantial portion of the Kenyan population, particularly ordinary citizens who relied on accessible and localized communication channels. They deposed that the said notice did not necessarily reasonably reach rural communities, citizens without access to national media, citizens relying on vernacular radio stations, and those who depended on local public fora for information. It stated that National Assembly reduced 290 potential local hearings to only 47 hubs for public engagement forums, including venues such as Kiambu Social Hall, Gatundu, Nakuru ASK Shule, and Tomboya Labour College, thereby drastically limiting accessibility and diluting representation. Kituo cha Sheria averred that the National Assembly and the Senate did not take adequate steps to ensure that sufficient citizens were made aware of the intended impeachment process. In particular, had failed to disseminate information through churches, mosques, temples, public barazas, community meetings, vernacular radio stations, and county-level public participation forums. They further averred that the alleged public participation conducted by the National Assembly and the Senate lacked adequate structures for public engagement, including ICT-based platforms for the submission of views, decentralized citizens forums, structured mechanisms for receiving memoranda from citizens across counties, and organized town hall meetings. As a result, members of public were largely reduced to observers of the proceedings rather than participants in the process. They deposed that in the impeachment proceedings conducted by the Senate, by the Speaker of the Senate and the Senate on the 16th and 17th of October, His Excellency Gachagua was denied an opportunity to appear and be heard, to be present when being tried, and to challenge the evidence. That during the proceedings on the material day, it was communicated to the Speaker of the Senate, and the Senate, that is Excellency Gachagua, was present but subsequently fell ill. He was then rushed to hospital for urgent medical attention, and his legal counsel duly communicated his admission to hospital to the Speaker. Notwithstanding the request for adjournment on this ground, the Senate declined the request and proceeded to hear the case in the absence of His Excellency Gachagua and his counsel. The Senate subsequently decided to remove His Excellency Gachagua from office by impeachment for gross misconduct and on grounds of violation of the Constitution. Kituo stated in the proceedings of that the proceedings of the removal from office of the Deputy President before the Senate involved the reception of evidence, evaluation of contested facts, and the making of determinations that directly affected the fundamental rights of His Excellency. Those proceedings, therefore, ought to have been procedurally fair and to have accorded him an opportunity to be present during the trial, to be cross-examined, to be re-examined, and to fully clarify any allegations made. However, the Senate, in disregard of the quasi-judicial nature of the proceedings, reached its determination without affording His Excellency those rights. Kituo cha Sheria contended that declining an adjournment request when His Excellency suffered severe and involuntary pain constituting a medical emergency was inhumane and unreasonable. They further averred that the one-day public it was further averred that the Senate, as a state organ, was bound to follow the Constitution and to observe, respect, protect, promote, and fulfill His Excellency Gachagua's rights. That upholding the impeachment as conducted set a dangerous precedent by normalizing procedural shortcuts in constitutional processes and weakened safeguards meant to protect constitutionalism and the respect for the rule of law. The absence of cross-examination in the present case was, in his view, a novel and serious procedural omission that contravened national values and principles of governance, including good governance, integrity, transparency, accountability, fairness, human dignity, equality, social justice, inclusiveness, equality, human rights, non-discrimination, and protection. They expressed their belief that the court had a solemn duty in interpreting the Constitution to adopt a purposive and progressive approach that advanced good governance, constitutionalism, accountability, and the public interest. They further averred that the determination of the petition would provide critical guidance on the constitutional standards applicable to future impeachments of holders of the offices of the Deputy President and the President, and that it must therefore reinforce rather than dilute the public participation threshold and fair hearing protections. Kituo submitted that the standard for public participation envisaged under Article 118 was meaningful participation and not tokenism, and that it had to be assessed on reasonableness and meaningfulness and meaningful opportunity, considering the nature and the impact of the decision. It was submitted that the removal of a Deputy President from office was not an ordinary procedural matter, but constitutional event with profound democratic implications. That Article 118 had to be read together with Articles 1 and 10 of the Constitution, and that sovereign power belonged to the people, and Parliament merely exercised that power in a delegated capacity. When Parliament embarked on a process that might remove from office a Deputy President who was directly elected by the people, it was obliged to ensure that the people themselves were accorded a meaningful opportunity to be heard. It was further submitted that in such a context, public participation became a constitutional condition precedent to valid impeachment processes. The organization submitted that public participation in a constitutional democracy had to satisfy both quantitative and qualitative standards, and that this dual requirement was particularly important where the process concerned the removal of a nationally elected office holder. In support, they relied on the Mwangaza versus Speaker of National Assembly case, in which the court stated that public participation was a constitutional requirement, and Articles 10(2)(a) and 190 Article 1B of the Constitution mandating inclusive and meaningful citizen engagement in government decision making, including legislative processes such as impeachment. It was further submitted, relying on the case of Wambora, that the Constitution did not intend a scenario where an otherwise popular deputy president could be removed due to political rivalry, malice, vendetta, institutional tough wars, and partisan hostility within government, and that public participation acted as a constitutional safeguard against the abuse of impeachment powers. On the inadequacy of the notice period, the interested party submitted that the one-day Gazette notice and a national radio announcement coupled with two-day public engagement period was grossly inadequate to facilitate meaningful public participation, as such short time could not reasonably reach most Kenyans, particularly ordinary citizens who relied on accessible and localized information channels. On the over-centralization of venues, they submitted that the Speaker of National Assembly and the National Assembly failed to utilize several well-established participatory mechanisms ordinarily available to them, including ICT platforms for structured public input, county-based citizen engagement forums, public notice boards, and accessible announcements, town hall meetings, engagements through representation of the people, and decentralized partisan platforms across counties. Instead, the National Assembly adopted a centralized and restrictive mode whereby all 290 constituencies were grouped into only 47 participation centers, one per county. This arrangement overloaded single venues, diluted constitutional high-level representation, and transformed public hearings into mass gatherings where individualized contributions were particularly impossible. The structural barriers disproportionately undermined meaningful engagement, especially for marginalized communities, people with disabilities, workers unable to leave employment on short notice, those without transportation, and citizens living far from county headquarters. It was submitted that a process of this gravity required decentralized, not consolidation of engagement forums. On the rigid and non-deliberative format of engagement, they submitted that the National Assembly employed a highly structured and restrictive model of engagement in which parliamentary clerks read out the charges, provided a general explanation of the processes, attendees were given limited time to offer their views, and those views were recorded in a pre-designed format for compilation. That format did not allow robust deliberation, did not permit cross-examination of claims, and did not facilitate informed submissions on the constitutionality or factual basis of the impeachment. It was submitted that public participation had to be interactive and not merely a formalistic exercise. On the inadequacy of the online submission mechanism, they submitted that the National Assembly's website provided template forms where citizens could tick boxes indicating support or opposition to the impeachment, but those forms offered only binary choices, allowed no uploading or supporting documentation, and permitted no opportunity for dialogue or nuanced analysis. This reduced public participation to checkbox voting rather than substantive constitutional engagement. They acknowledged in their submissions that the standard required was not perfection, but reasonableness. However, reasonableness is in a matter of this magnitude required the Speaker of the National Assembly and the National Assembly to have actively mobilized public awareness through non-public convergence points such as churches, mosques, temples, public barazas, national radio stations, vernacular broadcasting stations, and other accessible civil forums. The failure to which those avenues significantly restricted the reach of the notice and consequently diminished participation. The process was submitted to have been conducted on an extremely short notice, centralized into 2 venues and structured in a rigid and non-deliberative manner, and procedurally shallow through form-based engagement, all of which demonstrated a failure to meet constitutional standards and calling to question the validity of the impeachment of His Excellency Gachagua. It was further submitted that the removal of a deputy president from office was not merely an internal matter of parliament, but a matter of national constitutional significance affecting the democratic will of the electorate, the integrity of the executive structure, the political stability of the Republic of Kenya, and the sovereignty of the people, and that accordingly the electorate had to be accorded an opportunity to participate in a process that sought to overturn their democratic choice. Kituo cha Sheria submitted that even where Parliament acted within its constitutional mandate, when it undertook a process that received and evaluated evidence and reached determinations adverse to rights, reputations, and the tenure of office, it was obliged to meet minimum content on procedural fairness. It was submitted that the Senate proceedings bore all the hallmarks of a quasi-judicial trial, from pleadings, evidence, contested facts, and was finding to a grave sanction in the form of removal from office, and that Articles 47 and 50 of the Constitution and the Fair Administrative Actions Act 2015 therefore applied with full force. Impeachment of a national executive was not a mere political debate, but a structured constitutional trial with legal standards burdened with reputational, civil, and democratic consequences, which made the rights to be present, to cross-examine, and to be re-examined all the more imperative. It was submitted that Article 50, read together with Article 25C of the Constitution, and that scored that fair trial rights were non-derogable in substance, relying on Stephen Odede versus Court Marshall, in which the court confirmed that the right to a fair hearing and right and fair trial ought not to be unduly impeded, and that a trial body had to be circumspect in purporting to limit and take away such crucial rights, since Article 25C specifically provided that there was never to be any derogation from the right to a fair hearing. It was further submitted that while impeachment was sui generis, the logic of adversarial testing of allegations applied with equal, if not greater force. His Excellency Gachagua fell ill, was admitted for urgent medical care, and his counsel sought an adjournment, which was refused. The Senate proceeded in absentia without counsel, received and assessed evidence, and removed him from office, thereby extinguishing his ability to be present, to be cross-examined, and to be re-examined, and to participate meaningfully. It was submitted that a fair process entailed reasonable accommodation, including adjournment, where good cause was shown and no prejudice will be suffered that could not be compensated by way of cost or by way of time. Kituo cha Sheria relied on Githiga and 5 others versus Kiruti Factory Company Limited, in which the Supreme Court confirmed that the right to a fair trial indicated that the right to a fair hearing indicated that an individual shall not be penalized by a decision affecting his rights or legitimate expectation unless he had been given prior notice of the case against him, a fair opportunity to answer, and the opportunity to present his case. It was submitted that this was precisely what was not accorded to His Excellency Gachagua. It was further submitted that if the Senate could adjourn an entire sitting over quorum issues as per Standing Order 40, then refusing to adjourn to accommodate a hospitalized party where fairness and due process rights were under Articles 47 and 50 were at stake was unreasonable, disproportionate, and constitutionally infirm. They argued that the right to be heard required a real and effective opportunity to participate, not a mere formality, and included the right to attend and to answer the case one first, as well as the right to correct and contradict the allegations made against one. Further, that an adjournment was a recognized incident of a fair hearing where unavoidable circumstances prevented attendance or effective participation, and accordingly the denial of a reasonable adjournment amounted to a denial of the right to be heard. The Senate could have proceeded in His Excellency Gachagua's absence if his conduct had made it impossible to continue the hearing, or if after due notice his notice was unjustified. In the present case, they submitted that that absence was explained as a medical emergency, and counsel had sought an adjournment. Proceeding to receive and evaluate adverse material in those circumstances, His Excellency Gachagua's ability to participate meaningfully was impugned. It was further submitted that in impeachment, the public interest was best served by accuracy and fairness, not speed for its own sake, and that where adverse oral evidence was received and weighed, cross-examination was then crucial for testing credibility, the denial of which hollowed out fairness and tainted the decision. It was submitted that expedition could not cannibalize fairness, and that Articles 10, 47, and 50 demanded reasonable accommodation, especially where a short adjournment would have cured the prejudice occasioned by a medical emergency. Kituo cha Sheria submitted that courts had emphasized committee and institutional respect, and that impeachment was principally a political and constitutional accountability process, but that Parliament had not been insulated from judicial scrutiny where constitutional requirements were breached. Relying on the Mwangaza case, Kituo cha Sheria recalled the court's pronouncement that impeachment was an invaluable safeguard against impunity and an abuse of office that had to be jealously protected and must not be allowed to become an avenue for fighting political proxy wars or resurrecting ballot box contestations. The court further stated that the court further stated therein that watering down impeachment, lowering its bar too low, or allowing it to become a facade, masking hidden political interests, ran the risk of Kenyans losing confidence in the process, and that the intervention of courts came far down the impeachment path, making it the duty of the primary duty bearers to ensure that impeachment remained a constitutionally envisaged. Kituo cha Sheria submitted that constitutional review was therefore available to term procedural impropriety in the exercise of public power, even in political charged arenas. County Assembly, wherein it was initiated, and the Senate, wherein it was concluded, but that the court might only come in when necessary to confirm that the process had been properly followed as laid down in the Constitution and the statute. Accordingly, they submitted that the question before the court was not how the Senate should have voted, but whether it had obeyed the Constitution in getting there. It was submitted that Article 10 of the Constitution bound all state organs whenever they applied or interpreted the Constitution or enacted, applied, or interpreted any law or made or implemented policy, public policy decisions, and required good governance, integrity, transparency, accountability, human dignity, equality, social justice, inclusiveness, equality, human rights, and non-discrimination. An impeachment that shut out the subject's presence, cross-examination and re-examination, especially medical emergency, subverted human dignity, equality of arms, and accountability, and was thus unconstitutionally infirm. Kituo cha Sheria was not asking the court to supervise the National Assembly and the Senate debate or to substitute their judgment, but only to ensure that in reaching their determination, the constitutional procedures were observed. They sought a declaration that the impeachment proceedings conducted on the 16th October 2024 by the Senate were procedurally unfair, unconstitutional, and ultra-vires. A declaration that the Senate, acting as a quasi-judicial body, violated Articles 47 and 50 of the Constitution by denying cross-examination, re-examination, and a reasonable adjournment in the alternative. A reasonable adjournment. In the alternative, if the court was minded to preserve the proceedings, an order of remit directing the de novo hearing before the Senate in strict conformity with constitutional and statutory fair hearing requirements, including presence, representation, examination, disclosure, and reasonable determination, and such other orders as the court may deem fit to vindicate the Constitution and the public interest in a lawful, rational, and fair impeachment process. Kituo cha Sheria concluded its submissions by urging the Constitution that the Constitution erected procedural safeguards precisely because impeachment was a constitutional earthquake, where the Senate refused a short adjournment despite His Excellency Gachagua's hospitalization, proceeded in absentia, and delivered the ultimate sanction without the presence, cross-examination, and re-examination of the accused. The process failed the constitutional test. It was submitted that this court ought to intervene not to rewrite politics, but to enforce procedure, and in so doing, preserve Kenya's commitment to the rule of law, constitutionality, accountability, and human dignity. We'll now proceed to responses and submissions to the consolidated petitions. We'll start with the second and the seventh respondents' cases. The National Assembly and the clerk to the National Assembly were the second and the seventh respondent in the consolidated petitions. They jointly responded to the petitions through a replying affidavit sworn by its clerk, Samuel Joroge, on the 9th of October 2024 and the 21st of October 2024, and the grounds of opposition dated 4th of October 2024. They asserted that the impeachment process was entirely constitutional, lawful, and procedural fair, and that all actions were taken, all actions taken complied with Articles 145, 150, and 118 of the Constitution, as well as the National Assembly standing orders, as well and the court directives. They further posited that the impeachment of the Deputy President followed Article 150, Sub-Article 2 of the Constitution, which applies Articles 144 and 145 of the for the President with necessary modification, and that Standing Order 65-2 of the National Assembly explicitly states that Standing Order 64 applies to the Deputy President with necessary modifications as well. They deposed that the Speaker validly confirmed that the motion met the required legal form and the signature threshold of at least 117 MPs, or 1/3 of all members. That public participation was adequate, inclusive, and compliant with court orders, as the National Assembly placed advertisements in all three national dailies on the 2nd, 3rd, and 4th of October 2024. Public hearings were held on the 4th of October 2024 across the country, and that public and the public will submit views by way of email, post, hand delivery. A dedicated template in English and Kiswahili was provided, and they were also able to visit the constituency offices. The respondents contended that upon with a court order on the 3rd of October 2024, they extended public participation to the constituency level until 5th of October 2025, and that a public participation report was published. They asserted that the process was real and not illusory, that public participation was not part of the Deputy President defense, as it was meant to gather general public views to inform the Assembly, and that holding it first preserved the integrity and the independence of public input, preventing it from being influenced by the Deputy President's defense or parliamentary debate. The respondents maintained that the Deputy President still received his full right to be heard during the debate on the 8th of October 2024, where he appeared in person with his legal team. The respondents further claimed that one of the petitioners, Honorable Jane Jeremiah, closed her Kirinyaga County Women Representative Office during public participation exercise, despite parliamentary officers being deployed there. Further, they reliably learned that the closure was directed by the woman representative herself, since she was vehemently opposed to the impeachment. The respondents averred that she cannot then benefit from her own actions that obstructed the public participation exercise. The respondents deposed further that after debate on the 8th of October 2024, the motion was put to a vote and 282 members voted in support of the impeachment and 44 voted against, which exceeded the required two-thirds majority under Article 145(2) of the Constitution. That on the 9th of October 2024, the Speaker of the National Assembly formally notified the Speaker of the Senate of the resolution by transmittal. The respondents denied any constitutional or otherwise wrongdoing and prayed that the constituted petitions against the National Assembly and the clerk be dismissed with course. In respect to their submissions, the National Assembly and its clerk's onslaught on the constitutional petition was led by learned counsel Mr. Eric Gumbo, Mr. Paul Nyamodi, and Honorable Gitonga Murugara. They identified the following issues for this court's determination. A, what is the extent of this court's jurisdiction to hear and determine the constituted petitions relating to the impeachment of His Excellency Gachagua? B, whether the sub judice rule under Standing Orders 89 and 103 of the National Assembly and the Senate Standing Orders bars parliamentary proceedings on impeachment where judicial proceedings are pending. C, whether the impeachment proceedings before the National Assembly were valid. D, whether the petitioners have demonstrated any valid grounds for challenging the impeachment proceedings conducted before the Senate. E, whether the impeachment unconstitutionally subverted the sovereign will of the electorate expressed in the 2022 general elections, contrary to Articles 1, 2, and 38 of the Constitution. F, whether the nomination, approval, and appointment of Honorable Kindiki as the Deputy President was invalid, and whether the petitioners are entitled to any of the reliefs sought. The National Assembly and clerk submitted that the impeachment of His Excellency Gachagua as Deputy President was constitutionally valid, procedurally proper, and politically necessary to uphold accountability and the rule of law. They also defended the subsequent nomination, approval, and appointment of Honorable Kindiki as Deputy President as fully compliant with the Constitution. Their positions remained that an impeachment is a political process, not a judicial one, and that the Constitution vests sovereign power in the people exercised through their elected members under Article 1, that the Constitution mandates public participation, strict timelines, and bicameral supermajority representation requirements of the two-thirds in both houses, making the impeachment framework rigorous and transparent. They submitted that the comparative analysis with the United States, Philippines, Brazil, South Korea, and Nigeria shows that Kenya's process aligns with global presidential systems where impeachment is a constitutional safeguard against abuse of office. On the High Court's jurisdiction under Article 165 of impeachment proceedings, they submitted that such power is only residual and supervisory, not appellate. That impeachment is a political process entrusted to Parliament, and courts should not interrogate the substantive merits of impeachment charges. They added that the court's role is limited to ensuring procedural compliance and protection of individual constitutional rights, and citing the cases in Wambora and Sonko. They asserted that the courts must show deference to Parliament in matters where the Constitution grants Parliament discretion. Learned Counsel also cited the decision of the Supreme Court of Philippines in Re Sara Duterte, which similarly held that courts will not encroach on co-equal branches on political questions. It was their further submission that Standing Order 89 of the National Assembly and 103 of the Senate do not absolutely bar discussion on matters pending in court, and a matter is sub judice only if discussion is likely to prejudice fair determination of active proceedings. They stated that the petitioners did not raise any sub judice objection during the parliamentary proceedings, and they cannot raise it now. The National Assembly and clerk submitted that the Constitution itself imposes tight timelines under Article 145, that is 2 days to notify Senate, 7 days to convene Senate, and 10 days for the committee investigation. They contended that impeachment is urgent, as prolonged proceedings will cause political uncertainty and undermine governance. The standing order were a legitimate excess of parliamentaries' power under Article 124 to regulate its internal affairs, and that timelines are constitutionally anchored and not subject to judicial invalidation, as was held in Mbarak Issa Kombo's case. It was their further submission that public participation was adequate, as the National Assembly issued notices in the Kenya Gazette, national newspapers, news website, and social media on the 2nd, 3rd, and 4th of October 2024. Public hearings were held at county and constituency levels, including compliance with Justice Mwongo's order on constituency level participation, and 223,083 citizens submitted views, which they stated was an unprecedented level of civic engagement. Further, that the public views the public views template was provided in English and Kiswahili. Submissions were received orally, in writing, and electronically. They also submitted that the constitutional standard is reasonableness, not perfection, and that the Supreme Court and Cabinet Secretary for National Treasury and Planning and 4 others versus Okoita and 52 others held that timelines must be considered when assessing public participation adequacy. They submitted that His Excellency Gachagua's response was not required to be circulated, was not required to be circulated simultaneously, as the public role is to express views, not adjudicate, and that allegations of violence, intimidation, and poor organization were unsubstantiated, and that isolated incidents do not vitiate an entire process. They also submitted that public participation report was submitted in Parliament and recorded in the Hansard, which is a valid parliamentary record. They stated that the impeachment motion was properly particularized and set out 11 detailed grounds with specific particulars, and that these grounds met the threshold set in the Wambora's case of being serious, substantial, weighty, with clear nexus and precise constitutional provisions. That the motion was supported by 282 MPs, which was well above the 2/3 requirement of 233 MPs, and that the Deputy President was accorded a fair hearing, as he received prior notice of the charges. He filed his written response and appeared in person with counsel, and he was given 2 hours to address the National Assembly. The National Assembly and the clerk also submitted that His Excellency Gachagua's defense was considered and debated before the vote, and that the 2/3 gender principle does not invalidate Parliament, as Articles 97 and 98 on the composition of Parliament have been fully complied with. On the 2/3 gender principle under Article 81B, it was submitted that this was an aspirational provision to be achieved progressively, not a condition precedent to Parliament's validity. And that Article 261 provides a mechanism for addressing legislative delays, and that no advice from the Chief Justice or action by the President has occurred to dissolve Parliament. They contended that accepting the petitioner's argument would void all legislation and action since 2013 and will be an absurd and constitutionally impermissible outcome. On the allegation of bias against the Deputy Speaker, they submitted that allegations were unproven, and further that the Deputy Speaker only performed administrative and procedural functions and that she did not vote. Further, no recusal motion was raised during the proceedings. They stated that the test for bias is objective, as stated in the Supreme Court in Rawal and others, and that the threshold had not been met in this matter. Council added their voice to the position that the Senate handled the impeachment hearings by hearing the charges in plenary, since Article 145, Subarticle 3A, mandates the Senate to convene and hear such charges. That Article 145, Subarticle 3B, uses the word may, and therefore the appointment of a special committee was discretionary and not mandatory, and the semicolon and in Article 145, Subarticle 3, do not convert the discretionary power into a mandatory obligation. They reiterated that the Senate motion to appoint a special committee on the 9th of October failed, as it was not seconded, and the Senate then properly proceeded in plenary. They relied on the Supreme Court court and Sonko case that confirmed that for governors, the Senate may proceed in plenary or by a committee, and that the same applies to the Deputy President. It was also their submission that the 10-day timeline for plenary proceedings was constitutional, as where the Constitution is silent, the Senate may regulate its own procedures under Article 124, Subarticle 1, and the 10-day deadline was a reasonable exercise of procedural autonomy to ensure expedition. Council submitted that impeachment must be concluded without undue delay, and the timeline reinforce accountability and good governance. It was their father's position that His Excellency Gachagua received a fair hearing in the Senate, as he was represented by counsel throughout. He was cross-examined at the National Assembly, and he cross-examined National Assembly witnesses, and he filed witness affidavits on the 12th and 13th of October 2024. They contended that the Senate did not refuse an adjournment, and reasonably, as senior counsel Muite was given from 2:30 p.m. to 5 p.m. to contact His Excellency Gachagua, that no medical evidence of either a doctor's report or prescription was provided to the Senate, and that the Senate offered to adjourn until Saturday, 19th, October 2024, within the constitutional time frame. But this motion failed on a vote. The National Assembly and the clerk submitted further that the decision to proceed in absentia did not violate fair hearing, as His Excellency Gachagua had already filed his evidence and opted out after cross-examining the National Assembly's witnesses. That no new evidence was introduced. All material before the Senate had already been placed before the National Assembly and forwarded to the Speaker, and time allocation was not disproportionate, as both parties were accorded equal time. The National Assembly submitted that it also could not call all its witnesses due to time constraints, and that this was a consequence of expedition and not bias. They further submitted that the Senate had no independent duty to conduct public participation, which under Articles 10 and 118 applies primarily to legislative functions. The Senate, when hearing impeachment, acts as a quasi-judicial capacity, not a legislative one, and that public participation occurs at the National Assembly during the initiation stage, not at the Senate at the trial stage. Council submitted that comparative practice in South Africa, USA, and in the USA, Nigeria, and Brazil confirms that the upper house role is adjudicatory, not participatory, and that the court in Mwangaza versus Speaker of the Senate held that public participation in gubernatorial impeachment occurs at the county assembly level, and the same applies in equal measure in this matter. The respondents contended that allegations of bias against the Senate Speaker remained unproven, as a Speaker's role is presiding and procedural, and he has no deliberative vote. That mere coalition membership does not establish bias, and that the petitioners have not pointed to any specific act or omission showing a real possibility of bias. They restated that the test for bias is objective, and the petitioners failed to meet it, as well as in respect of the Senate Speaker. It was the submission of the National Assembly and the clerk that the participation of Honorable Orengo and Honorable Amolo as counsel did not invalidate the proceedings, in that Article 77(1) restricts gainful employment that is inherently incompatible with state office, and that presenting a part in proceedings is not such an employment. That any alleged illegality would affect the advocates personally and not the validity of the impeachment process, and that no actual bias or procedural fairness has been shown. They further submitted that the Senate applied the correct standard of proof for impeachment, which is above a balance of probabilities but below beyond reasonable doubt, as set out by the Supreme Court in the Sonko and Wambora cases. The Senate found 5 charges substantiated, including gross constitutional violations, attacks on judicial independence, ethnic incitement, gross misconduct, and that the evidence was substantial and credible, including His Excellency Gachagua's own public admissions. Learned Counsel submitted and urged that the court should not undertake a merit review of the Senate findings. Counsel reiterated that impeachment does not subvert the sovereign will of the people, as it is not an affront to democracy, but an affirmation of accountability. That the Constitution provides for removal of elected officials for gross misconduct, constitutional violations, and crimes, and that the joint ticket of the President and the Deputy President does not create legal inseparability, as they are separate constitutional offices with distinct and accountability mechanisms and with distinct accountability mechanisms. Counsel gave comparative analysis of the US Vice President resignations while President Nixon remained, and Brazil's President Rousseff's impeachment while Vice President Temer assumed office when they submitted that removal of deputy does not require removal of the principal. They contended that Article 150 of the applies Article 145 with necessary modifications, and that this acknowledges distinct offices and not a merger. On the validity of His Excellency Kindiki's nomination, approval, and appointment, the National Assembly and the clerk submitted that a lawful vacancy arose by operation of law under Article 145(7), as the impeachment was valid. They stated that IBC clearance was not constitutionally required for a deputy president nomination under Article 149, and that the president merely sought information of the voter registration status and MP qualifications from IBC as a matter of prudence. Counsel submitted that IBC Secretariat acted within administrative mandate by providing information which is not commission-led constitutional function. Counsel referred this court to the Supreme Court advisory opinion in IBC versus AG 2025, where it drew a distinction between commission-led functions such as boundary delimitation and secretariat administrative functions, including the day-to-day operations. They submitted that providing information falls within the latter. It was their submission that His Excellency Kindiki met constitutional qualifications for appointment, as he is a Kenyan citizen by birth, qualified to be an MP and nominated by a political party, UDA, thus satisfying Article 137 as read with Article 148, and that his party membership was properly documented with the register of political parties. They contended that allegations of misconduct during His Excellency Kindiki's tenure as Cabinet Secretary were mere allegations, and that no judicial or quasi-judicial finding of culpability exists, and that the court in International Center for Policy and Conflict and 5 others versus AG, reported 2013, held that unproven allegations cannot disqualify a candidate. That holding a cabinet secretary position did not disqualify him under Article 77, as this provision prohibits gainful employment that creates a conflict of interest, but does not bar a state officer from seeking elective office. The council submitted that disqualification for holding state office is governed by Article 137, sub-article 2B, that requires resignation 6 months before a general election. But it is not applicable to a mid-term vacancy, which process under Article 149 is sui generis. The National Assembly submitted that the voting process complied with Article 149(1), which requires the National Assembly to vote on the nomination, which is an electoral determination by plenary, not an approval process requiring committee vetting. That the Speaker correctly distinguished between appointive officers subject to committee approval and the elective process of Deputy President under Article 149(1). It was argued that the Public Appointments and Public Appointments in brackets Parliamentary Approval Act and the Standing Order 45.3 do not apply to this sui generis constitutional process, and that the Supreme Court entrusted Society for Human Rights Alliance versus Matemo and 3 others held that where the Constitution provides a specific procedure, statute cannot add to or amend it. It was also their position that no public participation was required for the nomination under Article 149, sub-article 1, does not prescribe public participation, and that the nomination and approval is an executive-led elective process, not legislative business under Article 118. That it will be incongruous to require more process for a mid-term vacancy than a general election, where the ticket is approved by popular vote without prior public hearings. For the aforementioned reasons, the National Assembly and the clerk urged the court to dismiss all relief sought in the with the council submitting that no constitutional violations had been proved. The impeachment was procedurally regular and substantively justified. Damages are not automatic, as no breach had been established, and awarding damages would punish Parliament for performing its constitutional duty. That pension and retirement benefits are for honorable retirement, not for removal by impeachment, and that quashing the resolution and nullifying His Excellency Kindiki's appointment will create a leadership vacuum and constitutional chaos. Council thus urged this court to dismiss the constitutional petitions with cost to them, find that the impeachment of His Excellency Gachagua was lawful, constitutional and procedurally proper, and that the nomination, approval, and appointment of His Excellency Kindiki as Deputy President was valid and constitutional, and that the court should decline to grant any of the relief sought by the petitioners. On the 3rd and 4th respondents' cases, the Speaker of the Senate and the Senate, who are the 3rd and the 4th respondents respectively, challenged the consolidated petitions through affidavits sworn by Jeremiah Nyegenye, who is the clerk of the Senate and secretary to the Parliamentary Service Commission. The affidavit was deposed on the 21st of October 2024. From the outset, it was their case that under Articles 93(1), 96, sub-article 4, and 145 and 150 of the Constitution, the Senate is mandated by with the role of considering the impeachment of a deputy president. They asserted that process is guided by the National Assembly's Standing Order 64 and 5, which dictates the procedure for introducing and supporting an impeachment motion. To that end, it deposed that on the 1st of October 2024, Honorable Mutuse introduced a motion in the National Assembly seeking the removal of His Excellency Gachagua on the basis of 11 grounds. 11 grounds, including gross violations of the Constitution, undermining, devolution, attacking independence of judges, committing economic crimes, and public subordinating publicly subordinating the president. It was their position that the National Assembly conducted extensive public participation from 2nd to 5th of October 2024 and formally approved the motion on the 8th of October 2024. Following the approval, the Speaker of the National Assembly notified the Speaker of the Senate of the resolution in a letter received on the 9th of October 2024, which included the motion, electronic evidence, relevant Hansard reports, public participation, advertisement and reports, and court orders. He asserted that the Senate Speaker convened a sitting on the 9th of October 2024 through Gazette Notice number 13170, during which a motion to establish a special committee to investigate the matter was defeated. As such, the proceedings had to be held in plenary, and it was deposed that the Speaker designated 16th and 17th of October 2024 for the plenary hearings formalized in Gazette Notice number 13178. Speaking to the fairness in the process, the clerk deposed that on the 9th of October 2024, the Senate served an invitation to His Excellency Gachagua and the National Assembly to appear to submit witness details and evidence. It was the case that on the 14th of October 2024, His Excellency Gachagua indicated his presentation by Mrs. Swanya and company advocates and filed his response to the allegations alongside supporting evidence. They stated that the plenary hearings commenced on the 16th and 17th October 2024, and after the National Assembly concluded its case on the 17th of October 2024 at 1:15 p.m. His Excellency Gachagua, lead counsel Mr. Paul Muite, senior counsel, informed the Senate at 2:30 p.m. that his client was missing and had been taken ill. It was pointed out that after suspending the proceedings until 5 p.m., counsel requested an adjournment to 22nd October. He stated that a substantive, subsequent procedural motion to sit on Saturday, 19 October 2024, to meet the constitutional deadlines was defeated, prompting His Excellency Gachagua's counsel to exit the proceedings. They maintained that the Senate, a quasi-judicial body, exercised discretion in granting adjournments, and His Excellency Gachagua's counsel failed to provide cogent material evidence of his illness. As regards the constitutional timelines, it was their case that impeachment could not be posed without violating the Constitution. They refuted the claim that the trial occurred in absentia since His Excellency Gachagua had actively participated through his advocates' opening statements, cross-examination, and the National Assembly's witness and filing of the respective witness affidavits. In challenging the claim that the public participation was not conducted, the Senate and the Speaker stated that an order of the High Court in Kerugoya did not mandate the Senate to conduct public participation, as the Senate functions exclusively as a trial chamber akin to a court. In conclusion, it was disposed that the Senate voted on the impeachment charges, where 5 charges comprising ground 1 on gross violation of the Constitution, ground 4 on undermining the independence of judges, ground 5 fidelity to the oath of office, ground 6 on crimes under national cohesion, and ground 9 on gross misconduct and ground 9 on gross misconduct concerning NAS were substantiated by the required majority. The clerk deposed that the Senate resolved to impeach His Excellency Gachagua, a decision officially gazetted on 17th of October through Gazette Notice number 13400. On the foregoing, this court was urged to find that the impeachment power is inherently political and vests solely in Parliament, which triggered the political question doctrine, thereby inviting this court to exercise judicial restraint. Ultimately, the Speaker of the Senate and the Senate prayed that the petitions be dismissed with cause. The third and fourth respondents filed submissions dated for the 24th of April 2026, and they were highlighted by their legal team led by Professor Tom Objenda, Senior Counsel, Mr. Edwin Mukele, Ms. Mercy Thanji, Ms. Opola and Honorable Hilary Sigei. They maintained that the entire impeachment process meticulously complied with all constitutional timelines, including standing orders and the principles of natural justice. On the question whether His Excellency Gachagua was accorded a fair and reasonable opportunity to be heard, they submitted that the hearing aligned with the due process and the Audi Alteram Partem rule to define the threshold of a fair trial. They relied on the Black's Law Dictionary, 7th edition, at page number 725, and the Halsbury's Laws of England, 5th edition, 2010, volume 61, at paragraph 639. The dictionary defines the rights to be heard as follows, and they quote, the rule that no person is to be condemned unless that person has been given prior notice of the allegations against him and a fair opportunity to be heard is a fundamental principle of justice. This rule has been refined and adapted to govern the proceedings of bodies other than judicial tribunals, and a duty to act in conformity with the rule has been imposed by the common law on administrative bodies not required by statute or contract to conduct themselves in a manner analogous to a court. End of quote. To bolster their case, the Senate and the Speaker referred to the President in Evans, Kidero and 4 others, was Ndungu, Waititu and 4 others, 2014 Supreme Court decision, which approved the Supreme Court of India's decisions in Indru Ramchand, confirming that a fair hearing possesses 2 elements, namely the opportunity must be given and it must be reasonable. Council drew further support from the Uganda Supreme Court in Obiga versus Electoral Commission and another, and in Saulo Kandie versus James Kwambai Cheruyot, which is a Court of Appeal decision, to illustrate that the right to be heard is fulfilled when a party is supplied with the opposing evidence and given a full venue to present their case, comment, or call witnesses. As regards the sufficiency of written evidence and constructive waiver, they stated that His Excellency Gachagua fully participated in the initial phases of the trial by filing comprehensive responses, witness statements, and documentary of video exhibits, which legally constituted his defense in chief under Rule 6 of the second schedule to the Senate standing orders. They submitted that an oral hearing is not an absolute prerequisite for natural justice, and they fortified their position through the decision in Economic Freedom Fighters and 3 others was the Speaker of National Assembly. This is a South African case, and the Kenya Revenue Authority and Menginya versus Menginya Salim Magara's case. They also relate to Swalwarjan versus Race Relations Board Limited. This is a foreign case, as well as R versus Immigration Appeal Tribunal. They also referred to the case of Jacob Ochanda versus Kenya Hospital Association Limited, to demonstrate that a hearing can be fairly conducted through written representations. The Speaker and the Senate faulted His Excellency Gachagua, stating that because he chose to walk out of the proceedings after the Senate had voted down an adjournment, it was deliberate boycott. They implored the court to find that voluntary absence constituted a constructive waiver of the right to be heard orally. Support to that end was drawn from various authorities, among them Regina versus Jones, R versus Governor of Brixton Prison, and the Ghanaian Supreme Court case in the Republic versus High Court of Accra. They affirmed that the Senate acted within its lawful discretion when it denied His Excellency Gachagua's request to adjourn the proceedings due to his sudden hospitalization. In reference to the decision of the Supreme Court in Sonko and the Mate, the Senate, and the Speaker emphasized that courts must be slow to interfere with the internal affairs and the procedural discretion of Parliament. Further support was drawn from the decision of the Supreme Court in the famous cycle agencies case and 4 others versus Mansukulal, Ramji Kuria, where it was observed that an adjournment requires sufficient cause based on proper materials. They argued that without formal medical proof of total incapacitation, the Senate was not required to stop its proceedings. To further credence to the foregoing position, they found support from the decision in Serem versus Republic, Court of Appeal decision, and Okaka and another versus Odundo, High Court decision. And it was their case that the strict approach was dictated by the mandatory 14-day timeline to dispose of special motions under Senate Standing Order number 74-2A. On the question whether investigation of charges met the requisite standard of proof, the Senate asserted that it thoroughly investigated and voted on each individual charge according to the established intermediate standard of proof, which is above a balance of probability but below reasonable doubt threshold. It was their case that the standard was set by the Supreme Court in the Sonko case, which declared that proving even a single charge is legally sufficient to sustain an impeachment. Consequently, they submitted that the court must decline to re-evaluate the evidence or substitute its own finding for the political question decided by the Senate under Article 96, Sub-Article 4 and Article 145, Sub-Article 3 of the Constitution. On the question challenging His Excellency Gachagua's claim that the Senate acted unprocedurally by failing to form an 11-member special committee under Article 143, Sub-Article 3B, the Speaker and the Senate submitted that the word may in the Constitution and Rule 2 of Part 1 of the second schedule to the Senate standing orders grant the Senate absolute discretion to choose between a committee or full plenary. They submitted that such interpretation is anchored in the Supreme Court case in the matter of the Speaker of Senate rendering or referencing the matter of interim independent electoral commission and the Court of Appeal decision of Cooperative Bank of Kenya Limited and versus Banking Insurance Finance Union, which is a Court of Appeal decision. They contrasted Article 135, Sub-Article 3B with Article 152, Sub-Article 7 of the Constitution, which uses the mandatory phrase, shall appoint, when dealing with the dismissal of Cabinet Secretary. It was their case that since a motion to form a special committee was moved but failed to be seconded under Standing Order 70, the Senate properly proceeded in plenary, meticulously satisfying the oversight parameters affirmed in the by the Supreme Court decision in the Sonko case. As regards the contentious issue of public participation, they contended that there was no legal basis for the Senate to conduct a secondary round of public participation because the National Assembly had already completed a rigorous national public participation drive between the 2nd and the 5th of October 2024 through extensive media notices and public feedback templates. They submitted that to demand a repetitive exercise from the Senate will be an imprudent waste of state resources. Separately, the Speaker and the Senate submitted that during an impeachment trial under Article 145, 3A, the Senate acts exclusively as a quasi-judicial body evaluating specific charges rather than performing a standard legislative function, exempting it from public participation requirements of Articles 10 and 118. They dismissed the argument that Parliament was illegally constituted due to a threshold failure to implement the two-thirds gender rule. They further submitted that although the former Chief Justice David Maraga issued a dissolution advisory to the 4th President, the 12th Parliament dissolved by operation of law and the 13th Parliament was lawfully established following the general elections of the 9th August 2022. Seeking to rely on Article 261, Sub-Article 5 running to 7, the Senate and the Speaker submitted that the ground that the gender rule mechanism is intended to compel future compliance and not to retroactively invalidate state operations. They warned that declaring Parliament unlawful would cause an absurd constitutional crisis, invalidating national budgets, legislation, and public appointments, which violates the governance promotion mandate of Article 259 of the Constitution. They urge the court to practice judicial restraint as the gender dispute is actively pending before a 5-judge bench in Conchela and others as the Chief Justice and President of the Supreme Court in Kenya and others. The Speaker and the Senate rejected the allegation that the Senate was mandated to conduct an approval hearing for filling the subsequent vacancy of the office of the Deputy President. They pointed out that Article 149, Sub-Article 1 of the Constitution, expressly grants the exclusive mandate to vote on and approve a nominated Deputy President to the National Assembly, entirely omitting the Senate. It was their case that by applying the statutory construction principle established in the case of Federation of Women Lawyers Kenya, FIDA versus AG, the initiative of strategic litigation in Africa, statutes could be interpreted to override the explicit, statutes could not be interpreted to override the explicit text of the Constitution. On the strength of the foregoing submissions, the Speaker and the Senate urged the court to dismiss all the consolidated petitions with costs.
I will take over from the 5th respondent's case. The Attorney General, that is the 5th respondent, challenged the petitions through grounds of opposition dated 7th of November 2024. She argued that the court should not elevate Parliament's factual assessments since its role is strictly to ensure that reasonable inferences were drawn from the available evidence. It was her case that the removal proceedings against H.E. Gachagua were purely legislative, neither entirely administrative nor judicial, and therefore were not subject to standard administrative or judicial review as suggested under Article 47(3)(a) of the Constitution. Further, the Attorney General asserted that the court could not substitute the legislature's discretionary decision with its own, as doing so would constitute a usurpation of the constitutional functions of an independent branch of government. She maintained that the proceedings before the legislature were lawful, efficient, expeditious, and procedurally fair, since the adopted procedure successfully balanced the need to protect H.E. Gachagua's constitutional rights, safeguard the process from abuse, and prevented unnecessary disruptions to public administration. Regarding public participation, the AG clarified that the Constitution did not permit members of the public to vote on an impeachment motion, as that discretion was expressly reserved for legislators who constitutionally represent the sovereign will of the people. It was explained that the National Assembly's role in the impeachment process was strictly preliminary and did not bind the Senate, which acted as a distinct state organ responsible for substantive proceedings and the ultimate decision. It described the consolidated petitions as disguised appeals regarding the merits of Parliament's decision and argued that the judiciary lacked an appellate mandate over the impeachment of a deputy president, since it is ill-equipped and constitutionally not designed to review or reevaluate the socio-economic and political utilitarian calculations made by elected officials. Finally, the Attorney General defended the subsequent nomination and voting into office of His Excellency Kindiki, And it was her case that the replacement process under Article 149(1) of the Constitution was sui generis, qualifying neither as an election nor an appointment, which meant that the provisions of Article 137 did not apply. The Attorney General concluded that there were no procedural infractions that affected the outcome, that the transition process was conducted within constitutional timelines by the proper constitutional repositories, and that the consolidated petitions lacked merit. The fifth respondent submissions are dated 4th March 2026. They were orally highlighted by a team of counsel led by Professor Githu Muigai, Senior Counsel, alongside the Solicitor General, Mr. Shadrach Mose, Mr. Emmanuel Bita, now a judge of the High Court, and Mr. Charles Mutinda. The Attorney General submitted that accountable governance was a core part of the Constitution, which established removal from office through impeachment as one of the tools of governance amongst the many avenues of exercising oversight and facilitating accountability. He relied on the Supreme Court decision in Sonko, where the Apex Court stated that its purpose was to ensure integrity in leadership and prevent abuse of public office. It was the Attorney General's submission that the removal of proceedings for a deputy president was textually committed by the Constitution to the National Assembly and Senate, and that both institutions were vested with exclusive power to remove the deputy president, subject only to procedural requirements set out in the Constitution and in the standing orders, that both houses were free to determine the procedures for receiving and considering the evidence necessary to discharge their duty to conduct impeachment hearing. With regard to the constitutional basis for impeachment, the Attorney General cited Articles 150, 144, and 145 of the Constitution, which she submitted established a sequential two-stage process. In the first stage, a member of the National Assembly initiated the process by filing a notice of motions supported by at least a third of all the members, which motion, if passed by at least 2/3 of all the members, was then transmitted to the Senate for substantive hearing. On the substance of the charges, the Attorney General submitted that the charges against H.E. Gachagua were substantiated to the prescribed standard to warrant his impeachment. She identified the specific charges upon which H.E. Gachagua was found culpable. On the standard of proof applicable to impeachment proceedings, the Attorney General relied on Sonko and the Court of Appeal decision in Wambora, both of which we have already referred to, which had held that the standard was above a balance of probability but below reasonable doubt, and that the allegations must be serious, substantial, and weighty, and must disclose with a degree of precision the constitutional provisions alleged to have been grossly violated. The Attorney General submitted that this court should not sit on appeal over Parliament's evaluation of facts and should not substantiate the discretion of the members of the legislature with its own. The Attorney General further relied on the advisory opinions of the Supreme Court in the Speaker of Senate and another, as well as the matter of the IEBC 2011 Supreme Court decision for the proposition that governmental powers were distributed the institutional mandate of a Parliament. The doctrine of presumption of regularity was equally invoked, encapsulated the doctrine of presumption of regularity, and it was submitted that government action enjoyed a presumption of legality and that the burden lay on the challengers to demonstrate unlawfulness. The Attorney General relied on the Supreme Court's decision in Odinga and another versus IEBC, our court, and another and our court and another, as well as, it's the same decision, Odinga and another versus the IEBC, including our court and another, the Attorney General and another as interested parties and amicus. On a comparative jurisprudence, the Attorney General submitted that both the United States and the Philippines recognize the political nature of impeachment proceedings, and the power is vested in the legislature, thereby warranting judicial deference to the merits of legislative decisions. The Attorney General relied on the case of Nixon versus the United States, where the United States Supreme Court held that challenges to Senate impeachment procedures were non-justiciable under the political question doctrine, as well as the Duterte decision that we have already cited. On the part of the petitions relating to the nomination and approval of H.E. Kindiki, the Attorney General submitted that the provisions of Article 149 envisaged a sui generis procedure for the nomination and assumption into office of a deputy president. It was the Attorney General's submission that the process under Article 149 an appointment, as the text of the Constitution employed neither of those terms. In support of the sui generis nature of the process, the Attorney General drew on comparative constitutional provisions from the USA, Ghana, and Nigeria, each of which provided for a distinct mechanism of filling a vacancy in the office of Vice President through presidential nomination and legislative confirmation. The Attorney General submitted that as H.E. Kindiki was nominated by the President within 14 days after the vacancy arose, and the National Assembly voted on the nomination within 60 days, there had been no infringement of either the text or the spirit of the Constitution. Moving to the 9th respondent's case, the Honorable Mutuse responded to the consolidated petitions through a replying affidavit sworn on 22nd October 2024. He deposed that on 1st October 2024, pursuant to Article 150B, read with 145 of the Constitution and the Standing Order 64 and 65, he gave a notice of a special motion for the removal from office by impeachment of H.E. Gachagua. He was aware that the special motion was a time-bound exercise pursuant to the Standing Order 64.2 and 65, which required that it be disposed of within 7 days of the notice being given, failure to which it would be deemed as withdrawn. Honorable Mutuse averred that while Articles 145 and 150 of the Constitution and Standing Orders did not expressly require public participation in a special motion, Article 118(1)(b) of the Constitution imposed on the Speaker of Parliament the obligation to facilitate public participation in legislative and other business of Parliament and its committees. He deposed that it was in that spirit that the National Assembly, with a view to facilitate public participation, invited members of the public to submit their views, and public hearings were thereby conducted across all the 290 constituencies on 4th October 2024. A notice dated 4th October 2024 by the Clerk of the National Assembly extended the period of public participation to 5th October 2024. Honorable Mutuse confirmed that on 8th October 2024, Honorable Millie Odhiambo MP tabled the public participation report before the National Assembly. Honorable Mutuse further deposed that on the 3rd of October 2024, the High Court sitting in Kerugoya issued orders directing the National Assembly to organize, facilitate, and conduct further public participation at the constituency level, and that the National Assembly complied with those orders by extending the exercise to the 5th of October 2024. Honorable Mutuse stated that following the tabling of the public participation report, the members of the National Assembly debated the special motion and that H.E. Gachagua appeared in person for the hearing. After debating and hearing both parties, the members of the National Assembly met the threshold set under Article 145(2) by passing and approving all 11 grounds of the special motion. Honorable Mutuse affirmed that the entire impeachment process, from the tabling of the special motion dated 26 September 2024 at the National Assembly to the Senate's resolution, had fully complied with all legal procedure provided in the Constitution and relevant laws. Honorable Mutuse emphasized that this court had a judicial and not a political mandate, and that its function was to certify whether all procedural provisions of law had complied with constitutional principles, which was a judicial function. He averred that the issues raised by the petitions raised a political question, a principle of law that referred to cases that courts could not resolve because they involved questions about the judgment of actors in the executive or legislative branches and not the authority of those actors. Honorable Mutuse also cited the position taken by courts in Paraguay, India, Lithuania, and the Philippines to demonstrate that jurisdiction practicing a presidential system of government had been appreciative of the political question doctrine in impeachment matters. He tabulated comparative examples of impeachment proceedings of USA presidents to show that in those jurisdictions, the fate of impeachment was left to political devices as opposed to judicial determination. Honorable Mutuse further deposed that under Article 94(2) of the Constitution, the National Assembly and Senate manifested the diversity of the nation and represented the will of their people and exercised their sovereignty. In conclusion, he urged the court to appreciate the prudential standing principle of self-restraint as a jurisdictional limitation on its power and prayed that the petitions be dismissed. Honorable Mutuse filed written submissions. Those were dated the 15th of February 2026 and were supplemented on 5th of May 2026. They were anchored on two issues: whether H.E. Gachagua was validly impeached, and secondly, whether the impeachment process was procedural. He submitted that H.E. Gachagua was impeached on grounds on various grounds under the Constitution, violation of national laws, and gross misconduct arising from his conduct. It was Honorable Mutuse's submission that the question for the court was not the political wisdom of the impeachment, but whether the grounds for removal had met the constitutional threshold under Article 145(1). Honorable Mutuse further reiterated his position that public participation was not expressly required under Article 145 and 150 or the standing orders, and relied on the case of BAT, submitting that even if there were allegations of lack of public participation, the same would not automatically vitiate the process. He further submitted that the petitioner's demand for public participation in the Senate was legally untenable, as the Senate acted as a quasi-judicial forum during impeachment processes. He submitted that the duty of Senate was to ensure a fair hearing for the accused, not to solicit public opinion on the charges. Honorable Mutuse further relied on the mandatory constitutional timelines governing impeachment proceedings and relied on the Supreme Court's decision in Mate, which held that constitutionally prescribed timelines were of mandatory character and binding on governance processes. In his supplementary submissions, he expounded on the six-part Baker test to Kenya's constitutional framework. On the first formulation On textual commitment to a coordinate political department, he submitted that Article 150 expressly delegated impeachment to the National Assembly and Senate, satisfying the first condition. He relied on the Supreme Court statement in Sonko that where the Constitution required Parliament to determine a matter in the first place, the courts would be slow to interfere. On the second formulation, on the lack of judicially discoverable and manageable standards, he submitted that Article 145(7) envisaged the finality of the Senate's determination with no provision for judicial appeal or standard or review. On the third formulation, on the impossibility of deciding without an initial policy determination, he submitted that assessments of gross misconduct incompatible with the high calling and dignified status of the office and serious reasons to believe crimes had been committed were inherently political and policy-laden beyond the competence of courts. On the fourth formulation, on the impossibility of independent resolution without expressing lack of respect for coordinate branches, Honorable Mutuse submitted that a merit review of the Senate's determination would substitute the court's judgment for that of elected representatives, constituting a profound expression of disrespect for a coordinate branch. On the fifth formulation, that is the unusual need for adherence to political decision already made, Honorable Mutuse submitted that the vacancy created by the Senate's resolution had already been filled through the nomination, approval, and swearing-in of His Excellency Kindiki as Deputy President. He submitted that to reopen the impeachment question at that stage would create constitutional chaos, cast doubt on the legitimacy of the current office holder, undermine executive suitability, expose the political life of the country to prolonged chaos as cautioned in Nixon. On the sixth formulation, on the potential from multifarious pronouncements, Honorable Mutuse submitted that if the court entertained a merit review and reached a different conclusion from the Senate, conflicting pronouncements from different arms of government would undermine public confidence in all institutions and weaken the constitutional order. Honorable Mutuse therefore urged the court to appreciate the prudential principle of judicial self-restraint as a jurisdictional limitation on its power to hear and determine consolidated petitions on the basis that they raised a purely political question whose determination would be tantamount to subverting the will of the Kenyan people. He accordingly prayed that the consolidated petitions be dismissed with costs. The 10th respondent's case, the 10th respondent was the United Democratic Alliance, UDA, who challenged the petitions through grounds of opposition dated 6th October 2025. UDA claimed that the petition is untenable since it irregularly and craftily sought to convert political grievances into constitutional disputes, contrary to the Supreme Court decision in Sonko. Pursuant to the Supreme Court's advisory opinion in Speaker of the Senate versus the Attorney General, UDA urged this court to exercise restraint and avoid interfering with the proceedings of Parliament, except in the clearest cases of constitutional violations. The 10th respondent filed written submissions dated the 24th of August 2026, which were highlighted by Counsel Dr. Adrian Kimotho. On the procedure for impeachment, UDA submitted that Article 151 provided for the grounds of impeachment of a deputy president being gross violation of a provision in the Constitution or any other law, serious reasons to believe that the Deputy President had committed a crime under national or international law or gross misconduct. It's admitted that Article 152 applied the provisions of 144 and 145 with necessary modifications to the removal of the Deputy President. The UDA submitted that having been accorded a right to be heard both at the National Assembly as well as the Senate's stage and to be represented in the proceedings, His Excellency Gachagua was found culpable of publicly attacking and undermining the work of the NIS and its officials, undermining the institutional, functional, and decisional independence of judges, and persistently making inflammatory, reckless, and insightful public utterances threatening to discriminate against and exclude sections of the people of Kenya from public service appointments and allocation of public resources amounting to gross violation of the Constitution. It was submitted that the charges were proven to the requisite standard and that the procedure of impeachment under Article 145, 1 and 2 of the Constitution, as well as the applicable standing orders, was followed to the required standards. On the nomination and approval of H.E. Kindiki, UDA submitted that Article 149(1) of the Constitution required the President to nominate a person within 14 days of a vacancy arising and the National Assembly to vote on the nomination. It was submitted the article did not contemplate an appointment, approval of an appointment, nomination by a political party, or the holding of an election as erroneously alleged by the petitioners. UDA submitted that His Excellency Kindiki was nominated within the 14-day period. The National Assembly voted in support of the nomination on 18th October, which was within the 60-day period, and the Speaker of the National Assembly published the resolution via Gazette Notice 13401. It was submitted that the nomination, approval, and swearing in of His Excellency Kindiki were all done in accordance with the law and without any violation of Article 149 of the Constitution. UDA concluded by submitting that the people of Kenya, through their duly elected representatives in the National Assembly and the Senate, had impeached His Excellency Gachagua in order to safeguard integrity in leadership in accordance with the Constitution, the National Assembly and Senate standing orders, and all applicable laws. It was submitted that the decision to impeach His Excellency Gachagua reflected the will of the people of Kenya, which the court should uphold, and that the consolidated petitions were without merit and ought to be dismissed. I look at the 16th respondent's case. That was the IEBC, responded to the consolidated petitions through the replying affidavit of Marjan Hussein Marjan, the then Chief and Commission Secretary, deposed to on the 25th of October 2024. IEBC refuted the petitioner's claims that it was legally incapacitated, deposed to on the 25th of October 2024. Its case primarily addressed two distinct legal issues raised by the petitioners, namely the constitutional validity and capability of IEBC as currently constituted, and the purported role of the IEBC in clearing or approving a deputy president appointed under Article 149 of the Constitution. IEBC refuted the petitioner's claims that it was legally incapacitated due to the vacancies of the commissioners and that it is an independent commission with perpetual existence established under Articles 88(1) and 253 of the Constitution, as read with Section 13 of the IEBC Act. Specifically, it relied on Section 7.3 of the IEBC Act, which states that the IEBC shall be properly constituted, notwithstanding any vacancy in its membership. It was its deposition that Sections 11A and 11.2 of the IEBC Act structurally divide IEBC into commissioners who are responsible for policy and strategy, and a fully staffed secretariat which is responsible for day-to-day administration and implementation. It was further its deposition that under Articles 145 and 150, the Constitution dictated the actors, the timelines, the procedures involved, which exclusively empower the legislature and exclude the IEBC. Similarly, it was the IEBC position that Article 149(1) of the Constitution mandates the President to nominate a replacement deputy president within 14 days of a vacancy for parliamentary approval. Flowing from the foregoing, the IEBC deposed that the omission of the IEBC in the process signified that the framers of the Constitution did not intend for an electoral body to validate executive midterm appointments. Finally, the IEBC addressed the petitioners' flawed reliance on Sections 99 and 137 of the Constitution. It clarified that the articles relate strictly and unequivocally to the qualifications of individuals seeking election as a member of parliament or president, respectively. The IEBC claimed that because a midterm vacancy under Article 145 and 150 trigger a nomination rather than a by-election, the clearance protocols under Articles 99 and 137 were not activated. The IEBC stated that while the IEBC maintains the voter register under Article 88(4)(a) of the Constitution and the IEBC Act, and provides public information as required by Section 35 of the Constitution and the Access to Information Act, it is not mandated to vet a nominee's educational, moral, or criminal background, as those duties belong to other state agencies like the EACC and the DCI, and as such, IEBC urged the court to dismiss the consolidated petitions. The IEBC filed submissions dated 27th October 2024, reiterating the deposition of Marjan Hussein Marjan. It was its case that it has no constitutional or statutory role in filling a vacancy in the office of the Deputy President. It maintained the position that Article 149 is a self-executing mechanism requiring only a presidential nomination and parliamentary approval with no mandate for elections, referenda, or IEBC intervention. To that end, it relied on the Supreme Court's decision in Attorney General versus two others versus D and 79 others, which is a Supreme Court decision which established that constitutional and statutory bodies must operate strictly within the four corners of their mandate and cannot extend their powers through implication or interpretive craft. It submitted that compelling it to participate in the deputy presidential appointment process would validate the doctrine of separation of powers, violate the doctrine of separation of powers by encroaching on the explicit functions of the President and the National Assembly. It called to its aid the Supreme Court's holding in the matter of interim Independent Electoral Commission, which underscored the mutually countervailing roles of different government organs. It also cited the South African constitutional case of Affordable Medicine Trust and others versus Minister of Health and others. Lastly, the IEBC reiterated that it enjoys perpetual succession and corporate legal personality under Article 253 of the Constitution and Section 13(1) of the IEBC Act, and it was its submission that despite temporary vacancies in its membership, it remained properly constituted. The IEBC therefore invited the court to dismiss the petitions against it as unmerited. The case presented by His Excellency Kithure Kindiki, who was the second interested party in the consolidated petition. His Excellency Kindiki challenged the petition through his replying affidavit and further affidavit deposed on 20th February 2025 and 8th May 2026, respectively. At the outset, he defended the swift timeline of his nomination and approval and clarified that the Constitution mandates the filling of the Deputy President vacancy within a maximum of 74 days, which were not a minimum, thereby making the expedited process entirely legal. Regarding public participation, it was his case that the National Assembly conducted extensive and adequate public engagement that met the legal thresholds. To that end, he deposed that there were newspaper advertisement, public hearings, and comprehensive reports. It was his position that the Senate acted as a trial forum rather than a legislative body during the impeachment hearings, meaning it was not constitutionally required to conduct public participation. In addressing the allegations regarding his eligibility, he maintained that the IEBC Secretariat had the administrative capacity to confirm his voter registration status without requiring a fully constituted commission. He also dismissed claims that he was ineligible for failing to hold a 3-month political party membership, explaining that this requirement applied strictly to general elections, not to the filling of an unforeseen vacancy. Further to the foregoing, it was his case that he provided Gazette notices proving that he had resigned from his position as Cabinet Secretary prior to his appointment. He clarified that the law permitted Cabinet Secretaries to hold ordinary political party membership. As regards the Senate refusal to grant His Excellency Gachagua an adjournment after he allegedly fell ill during the trial, His Excellency Kindiki observed that His Excellency Gachagua was granted an opportunity to appear in person and be represented by advocates of his choice before both houses of Parliament. He deposed that he made both oral and written representation at both houses of Parliament, challenged the inculpatory evidence before houses of Parliament, and through cross-examination of all adverse witnesses in the trial held at the Senate. Further, he deposed that H.E. Gachagua appeared healthy during his initial testimony and found it highly suspicious that he failed to present any formal medical diagnosis or report to the Senate to substantiate the sudden illness. He argued that granting the requested 3-day adjournment would have violated strict constitutional timelines under Article 145(4) of the Constitution that required the Senate to conclude impeachment proceedings within 10 days, failure to which would have potentially plunged the country into a constitutional crisis. In his supplementary affidavit, His Excellency Kindiki opposed the late introduction of medical records by Dr. Daniel Gikonyo. He faulted the affidavit for having been sworn a year and a half after the impeachment events and was introduced only after the primary petitioner had already closed their case. He highlighted material inconsistencies regarding the timing, preparation, and late disclosure of the medical records. Specifically, he highlighted that they were never presented to the Senate, the primary constitutional forum. His Excellency Kindiki urged his case further through written submissions dated the 1st of October 2025, which were highlighted by Learned Counsel Dr. Modhomi Thiankolu, Senior Counsel, and Mr. Kenson Muteithia. They structured it to symmetrically address both the substantive and procedural validity of the impeachment process in the National Assembly and the Senate, as well as the constitutional legality of His Excellency's nomination and election. Regarding the substantive validity of the impeachment, Dr. Thiankolu, Senior Counsel, submitted that His Excellency Kindiki was lawfully apologies, there's a mistake here. That His Excellency Gachagua was lawfully removed from office on 5 distinct counts, which included making persistent inflammatory public statements, undermining the decisional independence of the judiciary, and publicly attacking the NIS. To support the argument that the judiciary should not substitute its own judgment for that of Parliament, it was his case that the Supreme Court, in the case of Sonko, and the High Court decision in Wambora, held that the courts exercised only supervisory jurisdiction over impeachment disputes and could not act as a super legislature to review the sufficiency of the evidence presented to Parliament. In defense of the procedural mechanisms employed, His Excellency Kindiki urged that the National Assembly fulfilled its mandate by adequately informing the public and facilitating public participation, referring to the BAT case. He further implored the court to find that the strict offline impeachment timeline was a rigid constitutional framework, and to fortify its position, he referred to the Supreme Court's decision in Mate, where it was observed that timelines were not subject to alteration. In challenging the claim of denial of the right to fair hearing, His Excellency Kindiki asserted that the Senate's refusal to grant a 3-day adjournment In challenging the claim of denial of the right to a fair hearing, His Excellency Kindiki asserted that the Senate's refusal to grant a 3-day adjournment was an attempt to sabotage the proceedings and trigger a constitutional crisis. Had failed to produce medical evidence to substantiate his sudden illness. He reiterated that granting the adjournment would have blatantly violated the strict, non-modifiable constitutional timelines. Turning to the validity of His Excellency Kindiki's assumption of office, Dr. Thiankolu submitted that his speedy nomination, electoral clearance, and political party membership was justified. He drew support from the court's decision on 31st October 2024, which established that the critical functions of the Deputy President's office abhorred a vacuum and demanded expeditious action. Finally, His Excellency Kindiki contended that the statutory laws governing appointive state offices, such as the Public Appointments Parliamentary Approval Act, did not apply to the elective office of the Deputy President.
We now come to issues for determination. Upon careful consideration of the petitions, the responses thereto, the written and oral submissions of all parties, we have distilled the following issues for determination. For clarity and issue of reference, the principal issues and their attendant sub-issues are set out below. Issue number 1, jurisdiction, and Under jurisdiction, the issue is the justiciability of the petitions filed in light of the doctrine of separation of powers and the political question doctrine. Issue number 2, predetermination and bias. Whether there was predetermination and bias by the mover of the motion, the Speaker of the National Assembly, and the Senate during the proceedings. And 2, whether the first to the 11th respondents conspired or schemed to remove Honorable Gachagua from office in violation of Articles 1, 27, and 38 of the Constitution. Issue number 3, public participation. Whether there was adequate public participation at the National Assembly. 2, whether the Senate was obligated to conduct public participation, and if so, to what extent. 3, whether public participation was required at the point of nomination and appointment of His Excellency Kindiki. Issue number 4, constitutionality and legality of the standing orders. 1, whether standing order number 64, sub-order 2, and 65 of the National Assembly are unconstitutional. 2, whether standing order number 75, 78, 79, and 80 of the Senate are unconstitutional. Issue number 5, composition of the National Assembly and the IEBC and the nomination of the Deputy President. 1, whether the National Assembly was properly constituted to consider the impeachment motion in light of the 2/3 gender rule. 2, whether the nomination of a Deputy President can be legally finalized or approved in the absence of fully constituted commissioners of the IEBC under Articles 82 and 88 of the Constitution. 3, whether the nomination of Hon Kindiki while serving as a cabinet secretary is constitutionally infirm for violating the eligibility criteria under Article 148 as read with Article 137. Issue number 6, constitutional processes. Whether the Senate was obligated under Article 150 sub-Article 2 to apply Articles 144 and Article 145 with the necessary modifications to the Deputy President, and whether its failure to do so rendered the process invalid and unconstitutional ab initio. We'll also look at relevant standing orders and doctrine of immunity. 2, whether Parliament was obligated to consider and exhaust alternative accountability mechanisms, that is criminal, civil proceedings, EACC, DCI, etc., and whether the lack of legislation to operationalize Article 150 of the Constitution vitiates the impeachment. 3, whether the Senate ought to have established a special committee under Article 145 sub-Article 3 of the Constitution. 4, whether the speed of the gazettement of the Senate resolution, the nomination of His Excellency Kindiki by His Excellency President Ruto, and the voting by the National Assembly on His Excellency Kindiki as the DP nominee contravened the Constitution and the law. And issue number 7, fair trial. Whether the trial conducted by the Senate in respect of His Excellency Gachagua was lawful, fair, and in conformity with the constitutional guarantees of fair administrative action and fair hearing under Article 47 and Article 50 of the Constitution, respectively. We shall now turn to the analysis of each issue and its attendant sub-issues in the order set out above. Jurisdiction. The position in owners of the motor vehicle vessel Lydian S. versus Caltex Oil Kenya Limited, 1989 KLR1, remains as instructive today as it was when it was first pronounced, that jurisdiction is everything and a court that proceeds without it does so in vain. It is therefore necessary, before turning to the substantive grievances raised in these petitions, to resolve the threshold jurisdictional question that permeated the pleadings and submissions of almost all parties on whether the impeachment of a deputy president is amenable to judicial scrutiny or whether it falls exclusively within the political domain of Parliament and is therefore beyond the reach of courts. The respondents urge this court to exercise restraint, contending that impeachment is a political accountability mechanism constitutionally entrusted to Parliament, and that courts ought not to transform themselves into appellate chambers reviewing parliamentary decisions. The petitioners maintained that while impeachment is undoubtedly political in context and consequence, it remains a constitutionally regulated process subject to constitutional supremacy, the Bill of Rights, and judicial oversight. The resolution of these competing positions requires an examination of the constitutional architecture established under the Constitution of Kenya 2010. The starting point is the supremacy and delegated authority provisions found in the Constitution. Article 1 vests all sovereign power in the people of Kenya to be exercised either directly or through democratically elected representatives. Parliament, the executive, and the judiciary are therefore not sovereign institutions in themselves. They are repositories of delegated sovereign authority, deriving their legitimacy from and remaining accountable to the people. Article 2 declares the Constitution to be the supreme law of the Republic, binding all persons and all state organs at both levels of government. The inevitable consequence is that no state organ, including Parliament, enjoys immunity from constitutional scrutiny. The Constitution of Kenya does not recognize parliamentary supremacy. It entrenches constitutional supremacy, and that supremacy is absolute and admitting of no exception. The Supreme Court gave authoritative expression to this principle in Justice Kariuki Mate and another versus Martin Nyaga Wambora and another 2017 EKLR, where it emphasized that no arm of government is above the law, that this being a constitutional democracy, the Constitution is the guiding light for the operations of all state organs. It further determined that the court's mandate, where it applies, is for the purpose of averting any real danger of constitutional violation. It follows, as a matter of necessary constitutional logic, that whenever Parliament exercises authority under Articles 145 and Article 150 of the Constitution, it does so not as a sovereign body wielding unreviewable discretion, but as a constitutional organ exercising delegated authority within and subject to the limitations that the Constitution prescribes. The jurisdiction of this court to entertain these petitions is firmly grounded in Articles 22, 23, and 165 of the Constitution. Article 165, sub-article 3D, expressly empowers the High Court to determine questions of constitutional interpretation, including whether anything done under the authority of the Constitution or any law is inconsistent with or in contravention thereof, and it is precisely that question that lies at the heart of these proceedings. Article 23 vests in this court jurisdiction to enforce the Bill of Rights and to grant appropriate relief where constitutional rights and freedoms have been violated, are threatened, or are likely to be infringed. The breadth of that jurisdiction is a deliberate constitutional design that reflects the transformative aspirations of the Constitution of Kenya 2010 and the indispensable role assigned to the judiciary as the ultimate guardian of constitutional supremacy and the protector of the rights of every person within the Republic. This court does not approach the jurisdictional question as one of first impression. In its ruling delivered on 31st of October 2024, this bench considered and conclusively determined the self-same jurisdictional challenge that the respondents now seek to resurrect. The court held that the broad jurisdiction vested in the High Court under Articles 23, 22, and 165 extends to determining whether the powers exercised by the National Assembly and the Senate in impeachment proceedings conformed to constitutional requirements. Had the framers of the Constitution intended to exclude the High Court's jurisdiction in matters arising under Article 145, they would have done so in express terms, as they demonstrably did in relation to certain proceedings under Article 144. The argument that impeachment proceedings are beyond judicial scrutiny sits uneasily with the constitutional text. The Constitution contains no provision excluding impeachment from judicial review and no clause creating islands of authority immune from constitutional control. Where allegations are made that constitutional procedures are violated, rights infringed, or constitutional standards disregarded, as in the present case, this court would itself violate the Constitution were it to decline jurisdiction merely because the dispute arises in a politically sensitive context. As Chief Justice Marshall observed in Cohens versus Virginia, 19 U.S. 6 Wheat 264, in the year 1821, the court said, "It is most true that this court will not take jurisdiction if it should not, but it is equally true that it must take jurisdiction if it should. We have no more right to decline exercise of jurisdiction which is given than to usurp that which is not given. The one and the other, or the other, would be treason to the Constitution," close quote. That observation resonates fully within Kenyan's constitutional order. The presence of political implications does not extinguish this court's constitutional duty to interpret, protect, and enforce the Constitution. Even within the argument on separation of powers, this court accepts that impeachment is principally a parliamentary function under Articles 145 and 150. However, separation of powers does not mean separation from the Constitution. As the Supreme Court held in the matter of the Speaker of the Senate and another 2013 KLR, none of the arms of government can claim an exclusive preserve free from constitutional scrutiny, and it is the responsibility of the courts to ensure that the exercise of power by state organs remains within constitutional bounds. The Court of Appeal affirmed in Mumu Matemu versus Trusted Society of Human Rights Alliance and 5 others, that was in 2013, that the Constitution establishes not a rigid wall of separation, but a system of separation of powers tempered by checks and balances within which no arm of government is superior to another. The doctrine therefore requires mutual respect among constitutional institutions, not mutual exclusion, and Parliament cannot invoke it as a shield against constitutional accountability. Within the realm of impeachment proceedings, specifically the Supreme Court in Justice Karaoke Mate and another versus Martin Nyaga-Wambura of 2017, the Supreme Court signaled that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the courts is restricted by the doctrine of separation of powers to deciding on matters of individual rights and fundamental freedoms, and not to inquire into how the county assembly and the Senate perform duties in which they alone have discretion, nor to review the merits of the decision to impeach. We are therefore satisfied that this court is being correctly called upon to scrutinize and pronounce itself on the constitutional regularity of the impeachment process. To do so neither impinges upon nor offends the doctrine of separation of powers. As the Constitutional Court of South Africa observed in Doctors for Life International versus Speaker of the National Assembly and others, in quote, while the doctrine of separation of powers is an important one in our constitutional democracy, it cannot be used to avoid the obligation of a court to prevent the violation of the Constitution. The right and the duty of this court to protect the Constitution are derived from the Constitution, and this court cannot shirk from that duty, close quote. That proposition applies with equal, if not greater force within Kenya's constitutional order. To decline the obligation of constitutional adjudication in deference to the political character of impeachment proceedings would not be an act of judicial restraint, but an act of judicial abdication. On the political question doctrine, the respondents placed reliance on Nixon versus the United States, 506 USA 224, 1993, where Walter Nixon, a federal district court judge removed from office by the Senate, challenged the procedure by which his impeachment trial had been conducted. The United States Supreme Court held that the manner in which the Senate conducts impeachment trials is a non-justiciable political question, the conduct of such trials having been textually committed by the Constitution exclusively to the Senate. While Nixon offers useful guidance on the need for political restraint in matters constitutionally committed to other branches, a clear distinction must be drawn when transplanting that decision into the Kenyan constitutional context. The Constitution of Kenya contains an expansive Bill of Rights enforceable under Article 23, broad and explicit judicial review powers under Articles 165 sub-Article 3D, and a constitutional supremacy clause under Article 2 that expressly subjects every excess of power, of public power, without exception to constitutional scrutiny and accountability. Unlike the United States Constitution, the Constitution of Kenya does not textually commit impeachment proceedings to Parliament in terms of exclusive of judicial oversight. The place of the political question doctrine within Kenya's constitutional order has been authoritatively addressed by the domestic courts at the highest levels. The Supreme Court elaborated upon this position with specific reference to impeachment proceedings in Mike Mbuvi Sonko versus County Assembly of Nairobi 2022. The court held that courts are permitted to intervene where matters of constitutional violations arise in impeachment processes, reasoning that although impeachment is a political process sanctioned by the Constitution, neither the County Assembly nor the Senate can act outside the confines of the Constitution and the law. For to do so would invariably invite the court's intervention. The Supreme Court clarified that the mandate of the courts was to determine whether the individual's rights, dignity, and fundamental freedoms had been preserved and protected in the process without usurping the powers and functions of the legislative branch of government. Those principles were further articulated in a 5-judge bench decision of this court in Ramogi and 3 others versus Attorney General 2020, where the court held that the critical constitutional inquiry is not whether a dispute is political in character, but whether it raises constitutional or legal questions capable of judicial determination. Where constitutional standards exist against which the impugned conduct may be measured, a court is not at liberty to decline jurisdiction on grounds of political contentiousness alone. The court observed that were courts to decline jurisdiction whenever a dispute bore political implications, constitutional violations committed within political processes would be left entirely without remedy, an outcome fundamentally irreconcilable with Articles 2 and 3 of the Constitution. Taken together, these authorities establish that the political question doctrine in Kenya is not a doctrine of abdication, but one of restraint. It requires courts to distinguish between political choices entrusted to the political branches of government and questions of constitutional compliance entrusted to the judiciary. The former ordinarily lie beyond judicial competence. The latter falls squarely within the judicial function. In light of the foregoing, we reiterate that the court is not a political arbiter, but a constitutional one. We agree in principle with the submission that it is not the function of this court to determine whether the charges against His Excellency Gachagua were of sufficient gravity to warrant his removal from office. Those are quintessentially parliamentary judgments, constitutionally entrusted to the National Assembly and the Senate. We decline any invitation to venture into the merits of the charges upon which the impeachment was founded. The court's obligation is to ensure that the impeachment process, however political its character and however significant its consequences, was conducted in accordance with the Constitution, the rule of law, and the procedural and substantive safeguards the Constitution prescribes. Where that standard was met, we will say so. Where it was not, we are equally bound to say so. For it is in the faithful discharge of that obligation and not in deference to political outcomes that the legitimacy of this court's intervention ultimately rests. Accordingly, we find that the impeachment proceedings challenged in these petitions are justiciable, and that this court possesses jurisdiction under Articles 23, 22, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. Second sub-issue, predetermination and bias. The petitioners contended that the impeachment proceedings against His Excellency Rigathi Gachagua was tainted by actual bias, apparent bias, conflict of interest, and predetermination on the part of the speakers of the National Assembly and the Senate, members of Parliament, senators, and other constitutional actors involved in the impeachment process. It was their case that various public statements, political conduct, and procedural decisions demonstrated that the outcome of the impeachment had effectively been determined before the proceedings commenced, and that the constitutional actors involved had failed to approach the process with the impartiality and openness required under Articles 27, 47, and 50 of the Constitution. The constitutional foundation of the petitioner's claim lies principally in Article 27, 47, and 50 of the Constitution. Article 27 guarantees equality before the law and the equal protection and equal benefit of the law. Article 47 guarantees every person the right to administrative action that is lawful, reasonable, and procedurally fair. Article 50, sub-article 1 guarantees every person the right to have any dispute that can be resolved by the application of law determined in a fair and public hearing before a court, or where appropriate and independent and impartial tribunal or body. The constitutional requirement of impartiality is not confined to courts of law. Whenever a constitutional body exercises adjudicative, disciplinary, investigative, or quasi-judicial authority affecting rights, interests, status, or public office, the process must comply with constitutional standards of fairness, impartiality, and procedural propriety. This principle was affirmed by the Court of Appeal in Sholei versus Judicial Service Commission and 3 others in 2013, and the Judicial Service Commission versus Mbalu Mutava and another Civil Appeal number 52 of 2014. Where the court emphasized that constitutional and administrative decision-making processes are subject to the requirements of procedural fairness and natural justice. In Mbalu Mutava, which I've mentioned above, the Court of Appeal observed that Article 47 transformed the common law principles of natural justice into constitutional imperatives, such that whenever public power is exercised in a manner affecting legal rights, status, or legitimate expectations, constitutional standards of fairness become directly applicable. In Sholei case, the Court of Appeal reaffirmed that public bodies exercising disciplinary or quasi-judicial authority must act fairly and impartially, and that public confidence in constitutional institutions depends not only on actual fairness, but equally upon its appearance. The rule against bias is one of the oldest and most fundamental principles of natural justice, embodied in the maxim Nemo Judex in Causa Sua, that no person shall be a judge in their own case. Historically directed at preventing decision makers from participating in matters in which they held a personal, financial, or proprietary interest, the doctrine has over time expanded to encompass circumstances giving rise to a reasonable apprehension that a decision maker may not approach a matter with the requisite impartiality, even in the absence of any direct personal interest. The modern test for apparent bias was authoritatively stated by the Supreme Court in Rai and 3 others versus Rai and 4 others, 2013, KLR, where the court adopted the objective test and held that the inquiry must be conducted from the perspective of a fair-minded and informed observer. The court emphasized that allegations of bias cannot be founded upon speculation, conjecture, suspicion, or dissatisfaction with the outcome of proceedings. There must exist objective circumstances capable of giving rise to a reasonable apprehension that the decision maker may not bring an impartial mind to bear on the subject. The Supreme Court reaffirmed and elaborated upon these principles in Kaplana, Rawal, and two others versus Judicial Service Commission in 2016, observing that the question is not whether a party genuinely believes that a tribunal is biased, but whether a reasonable and informed observer, having considered all relevant facts, would conclude that there exists a real possibility of bias. The court further recognized that constitutional institutions must be protected from unsubstantiated allegations capable of paralyzing their functioning, and accordingly insisted upon an objective evidentiary foundation before a finding of bias can be made. Similarly, in Tunoi and another versus Judicial Service Commission and another Civil Appeal number 6 of 2016, the Court of Appeal reaffirmed the enduring principle first established in R versus Sussex Justices Ex parte McCarthy, 1924, 1 KB 256, that justice must not only be done, but must manifestly and undoubtedly be seen to be done, and underscored that public confidence in constitutional institutions depends significantly upon the appearance of impartiality and not merely its substance. From these authorities, several important principles emerge. First, the test for apparent bias is objective, not subjective. Second, the inquiry must be conducted from the standpoint of a fair-minded and informed observer. Third, mere suspicion, political disagreement, dissatisfaction with a decision or an adverse outcome does not, without more, establish bias. Fourth, and critically, there must exist objective circumstances capable of giving rise to a reasonable apprehension that the decision maker did not or could not approach the matter impartially. Jurisprudence further establishes that bias and predetermination, though related in concept, are legally distinct. Bias concerns the existence of actual or apparent partiality or on the part of the decision maker. Predetermination concerns a state of mind in which the decision maker has effectively closed their mind to the evidence and argument and reached a final conclusion before the process has run its course. The distinction was illuminated by the English Court of Appeal in Lewis versus Redder and Cleveland Borough Council in 2008, where the court drew a clear line between predisposition and predetermination. Decision makers may legitimately hold predispositions, inclinations, or preliminary views on matters before them. That is the inevitable consequence of experience and engagement in public affairs. What the law prohibits is predetermination, which is a state of mind so closed to persuasion that no amount of evidence or argument is capable of altering the ultimate outcome. In light of the authorities that we have cited, we hold the view that the mere fact that members of parliament or senators publicly supported or opposed the impeachment of His Excellency Gachagua cannot, standing alone, establish constitutional bias. To hold otherwise would render impeachment proceedings practically unworkable and would be inconsistent with inherently political character that the Constitution itself recognizes in such proceedings. Legislators are not expected to approach impeachment as blank slates devoid of political opinion or prior knowledge. What the Constitution requires is that they remain genuinely open to considering the evidence, listening to argument, and discharging their constitutional responsibilities in good faith and within constitutional limits. We are accordingly not persuaded by the proposition that bias may automatically be inferred from the fact that legislators belong to particular political parties, support particular political positions, or publicly express their views on political matters that may not necessarily be the views of the accuser. Such circumstances may be predisposition, but predisposition, as the authorities make clear, is not synonymous with predetermination. It is predetermination and not mere predisposition that constitutes a constitutional infirmity. The position of the speakers stand on an altogether different footing. the speakers do not determine the merits of impeachment charges. Under Article 145 and Article 150 of the Constitution, the power to impeach a deputy president is vested in the National Assembly and the state and the Senate, acting through constitutionally prescribed voting thresholds. The speakers neither debate nor vote on impeachment charges. Their function is essentially procedural and facilitative. They preside over proceedings, regulate debate, determine procedural applications, interpret standing orders, and maintain order within their respective houses. They are not, and were never intended to be, the substantive constitutional decision makers on the question of whether an impeachment should succeed or fail. We are accordingly not satisfied with the broad proposition advanced by some of the petitioners that the Speaker's mere participation in the proceedings or involvement in political agreements is sufficient to establish constitutional bias or conflict of interest. The constitutional decision makers under Article 145 and Article 150 are members of Parliament and senators collectively acting through the respective houses of Parliament. We therefore find that the allegations of bias, predetermination, and conflict of interest advanced by the petitioners against the Speaker's members of Parliament and senators are, on the material before this court, no more than bare and unsubstantiated assertions grounded in political inference and suspicion rather than in objective evidence capable of satisfying the test authoritatively prescribed in the Rai, Rawal, and Tunoi decisions.
The other main issue relates to public participation. In dealing with this topic, we address ourselves to three distinct but interrelated questions. First, whether the public participation exercise conducted by the National Assembly met the constitutional threshold required under Articles 10 and 118 of the Constitution. Second, whether the Senate, upon receipt of the impeachment motion, was itself obligated to carry out a public participation exercise before voting on the impeachment. And third, whether the public participation was required at the point of nomination and appointment of His Excellency Kindiki as Deputy President. The petitioners collectively contended that public participation in the impeachment process was constitutionally deficient, inadequate, and in certain stages wholly absent, rendering the entire process null and void. Their challenge was mounted at the three levels, and the petitioner advanced, they attacked the National Assembly's public participation exercise as being deficient, both in substance and procedure. They argued that the public was given less than 48 hours to digest complex charges, that the template used reduced their participation to binary support or not support choice, that His Excellency Gachagua's own response was withheld, depriving citizens of balanced information, that many venues were inaccessible, changed without notice, or restricted to party members. They also pointed to defiance of conservatory orders requiring constituency-level hearings, vagueness of the same-day notice of the 5th October 2024, anomalies in the participation report, such as a report support rate exceeding 100%, and tabling of that report moments before the debate. They also concluded that the scale of participation of about 200,000 citizens out of a population of 52 million was negligible and incapable of meeting the constitutional standards. With respect to the Senate, they contended that Senate conducted no public participation at all, no notices were issued, no hearings convened, no submissions received. They emphasized Senate's role was determinative and quasi-judicial, and therefore attracted an independent obligation to facilitate public participation. They argued that this obligation could not be discharged vicariously through the National Assembly, and that by proceeding without its own engagement, the Senate compounded the defects of the Assembly's process and arrogated sovereign power that the Constitution requires to be exercised by the people. Finally, they challenged the approval of H.E. Kindiki as Deputy President and argued that no public participation preceded the vote, yet that approval constitutes what is known as other business under Article 118, 1B, which requires public involvement. They highlighted the compressed timelines in the Senate impeachment vote on the 17th of October, the nomination of His Excellency Kindiki the same night, and approval by the National Assembly the following morning as evidence that the process was concluded overnight without public input. They distinguished this midterm vacancy scenario from a general election, noting that in elections, the people exercise sovereignty directly through the ballot, whereas in midterm appointments, public participation is the only available mechanism for engaging the people's will. And on that basis, prayed for declaration that the nomination, approval, and appointment of His Excellency Kindiki were unconstitutional. The respondents, quite in summary, maintained that the National Assembly's public participation exercise was adequate, it was reasonable, and fully compliant to the constitutional requirements. They argued that notices were disseminated through the Gazette, through newspapers, through Parliament website and social media, and that multiple channels of participation were available. They defended the 2 to 3 day notice period as reasonable, given the strict timelines under Article 145. They further justified the tick box template as a deliberate design to structure responses and prevent manipulation, noting that citizens could still submit their memoranda or oral views. They argued that participation by over 223,000 citizens was characterized as unprecedented civic engagement, and they dismissed the isolated disruptions as immaterial. They argued that there was no obligation to share His Excellency Gachagua's report with response with the public, since the public's role was to express views, not to adjudicate. On the Senate stage, the respondents, in summary, contended that the public participation was not required as the Senate seats as a quasi-judicial capacity during impeachment and not as a legislature. That Article 118 applied only to legislative business and not impeachment. That impeachment was a single continuous exercise with the public participation required only at the initiation stage. Regarding the nomination and approval of His Excellency Kindiki, they submitted that public participation was not required, that Article 149(1) established a unique self-executing process where the National Assembly voted as an electoral college exercising delegated sovereignty rather than conducting legislative business, that the Constitution's silence on participation in this context was very deliberate, and that elected MPs themselves embody public representation, that the debate was open, televised and recorded, and they concluded that the nomination, approval, and appointment of His Excellency Kindiki were fully compliant with the Constitution. We have considered the cases advanced by both parties and take the following position on this issue. It is common ground among the parties, and this court affirms that public participation is not merely a procedural formality, but a foundational constitutional value, one deeply woven into the democratic fabric of this nation. It is an expression of the sovereign will of the people, who, by virtue of Article 1, Sub-Article 1 of the Constitution, are the ultimate repository of all sovereign power. That sovereignty though delegated to state organs under Article 1.3, is not thereby surrendered. It is retained by the people and continuously exercised through, amongst other mechanisms, active and meaningful participation in the process of governance. Public participation is therefore not a gift of the state to the citizen, but a constitutional right that the state is obligated to facilitate, to protect, and to give full effect to. Under Article 10.2a of the Constitution, public participation is expressly enumerated as one of the national values and principles of governance. Article 10.1 makes clear that the national values and principles of governance bind all persons, state organs, state officers, and public officers whenever they make or implement public policy decisions, apply or interpret the Constitution or any law. The imperative of public participation finds further and specific expression in the context of Parliament in Article 118 of the Constitution, which reads as follows: Parliament shall, A, conduct its business in an open manner, and its sittings and those of its committees shall be open to the public, and B, facilitate public participation and involvement in the legislative and other business of Parliament and its committees. At its core, public participation refers to an active process of interaction and engagement among various stakeholders who have an interest in or are affected by a particular decision or course of action. The word active is of constitutional significance. It signals that the Constitution does not contemplate a passive, cosmetic, or performative exercise in which the exercise is merely notified of a decision, in which the public is merely notified of a decision already made. It demands instead a genuine and substantive process which the people are afforded a real and meaningful opportunity to shape the decisions that affect their lives. In essence, public participation is a mechanism through which the governed speak to those who govern, and through which the exercise of public power is continuously tethered to the will, values, and interests of the sovereign people. The robust jurisprudence on this subject in Kenya supports this position. The Supreme Court, in the matter of National Land Commission, this is an advisory opinion application number 2 of 2014, placed the principle of public participation at the very core of the concept of checks and balances in governance, recognizing it as integral to the manner in which various arms of government discharge their constitutional functions. Subsequently, in the British American Tobacco Kenya PLC versus Cabinet Secretary for Ministry of Health, commonly referred to as the BAT case, the Supreme Court delimited the following binding framework for public participation. The principles are that, as a constitutional principle under Article 10.2 of the Constitution, public participation applies to all aspects of governance, that the public officer and or entity charged with the performance of a particular duty bears the honors of ensuring and facilitating public participation, that the lack of a prescribed legal framework for public participation is no excuse for not conducting public participation, and the onus is on the public entity to give effect to this constitutional principle using reasonable means. That public participation must be real and not illusory. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. That public participation is not an abstract notion, it must be purposeful and meaningful. That public participation must be accompanied by reasonable notice and reasonable opportunity. Reasonableness will be determined on a case-to-case basis. That public participation is not necessarily a process consisting of oral hearings. Written submissions can also be made. The fact that someone was not heard is not enough to annul the process. That allegations of lack of public participation does not automatically vitiate the process. The allegations must be considered within the peculiar circumstance of each case, including the mode, the degree, the scope, the extent of public participation is to be determined on a case-to-case basis. Additionally, in Cabinet Secretary for National Treasury and Planning and 4 others versus Okiya Mtata, the Supreme Court held that the constitutional threshold for public participation is one of reasonableness, that the process must afford the public a genuine and meaningful opportunity to be heard, and that Parliament must take reasonable measures to ensure the proposal, views, and suggestions received. The court spoke as follows. In the BAT case, this court established the standard that duty bearers must meet and the threshold courts should use to determine whether duty bearers have fulfilled their obligations with respect to public participation. This threshold is set at a reasonableness standard. In its guiding principles on public participation, this court defined this threshold as follows: that public participation must be accompanied by reasonable notice and reasonable opportunity. Reasonableness will be determined on a case-to-case basis, close of quote. This and the broader corpus of jurisprudence firmly established that when the Constitution, the Constitution demands is not necessarily the most intensive form of participation in every case, but always a form that is meaningful, purposeful, and proportionate to the nature and gravity of the decision being made. This principle finds its clearest expression in the decision of the Constitutional Court of South Africa in Doctors for Life International versus the Speaker of National Assembly and others, where the court held that the degree and nature of participation must be calibrated to the subject matter and the potential impact of the decision on affected persons. The proposition has been consistently adopted by our courts in Mui Coal Basin Local Community and 15 others versus the Permanent Secretary, Ministry of Energy. The Court of Appeal affirmed that decisions of greater consequence demand more robust and substantive engagement, and that public participation ought to be meaningful rather than a tick box exercise. The High Court reinforced this position in Robert Gakuru versus Governor Kiambu County and Institute for Social Accountability versus the National Assembly, where it held that the standard of participation required is directly informed by the gravity and reach of the decision in question. We believe that it is within this rich conceptual context that the courts must approach questions about the adequacy of public participation in any given case, whether arising from the legislative process or from any other exercise of public power in which the Constitution demands the people's involvement. The focus ought to be on whether the participation that occurred was real, substantive, and meaningful. As we now turn to apply these principles to the specific facts of this matter, we do so bearing in mind that the constitutional standard is not one of perfection, but equally, it is not one of mere tokenism. The standard is meaningful participation, and that standard must be assessed with rigor, sensitivity to context, and fidelity to the constitutional vision of a government that is truly of, by, and for the people. Certainly, the impeachment of a deputy president is not an ordinary legislative act. It is amongst the most consequential, solemn, and irreversible decisions that any parliament can make. It involves the removal from office of a person who holds the second highest constitutional office in the Republic, and an office to which the holder was elected by the sovereign will of the people through a general election. The gravity of that decision cannot be overstated. It affects not only the individual whose tenure is at stake, but the constitutional architecture of the executive, the stability of government, and the democratic expectations of millions of citizens who cast their vote in the 2022 general election. It is precisely because of this gravity that the public participation required in connection with an impeachment process must be held to a standard that is both qualitatively and quantitatively meaningful. It is equally against this exacting standard that we assess the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua. On the question of notice, the National Assembly adduced evidence that notices of the public participation exercise were published in multiple newspapers of wide national circulation, including the Daily Nation, the Standard, the Star, and Taifa Leo on the 2nd, the 3rd, the 4th, and the 5th of October 2024. We recognize that the publication of the notices in both English and Kiswahili was a deliberate effort to reach citizens across the linguistic divide and to ensure that the exercise was not confined to the English-speaking, urban, and formally educated segment of the population. Notice was additionally published in the Parliament's official website and on social media platform, therefore extending the reach of the process to citizens who access information through digital means. On the question of accessibility and channels of engagement, a public views template was provided in both English and Kiswahili, further reinforcing the inclusive character of the exercise. Constituency offices and county women representative offices, altogether totaling 337 access points spread across every corner of the country, were directed to remain open, including on the 5th of October 2024, to receive public submissions. Citizens were further afforded the option of submitting their views by email, by post, hand delivery, and online submissions could be made through Parliament's website, which further meant that participation was not contingent on physical presence or geographic proximity to a hearing venue. On the question of numbers, the evidence shows that just over 223,000 members of the public participated in the exercise. We are mindful that the significance of a participation number cannot be assessed in a vacuum. It must be considered in the context of the time available, the channels provided, the nature of the decision being made, and the standards previously endorsed by the courts. The Supreme Court in the BAT case affirmed that both quantitative and qualitative components are relevant to such an assessment. Equally, in Robert Gakuru, the Court of Appeal affirmed the principle that the quantitative component of public participation is a relevant but not determinative consideration, and that the adequacy of participation must be assessed in light of all the circumstances. Viewed against these standards, a participation figure of 223 citizens achieved within the constrained timeline represents a considerable level of civic engagement in a single parliamentary process. We say so further considering the relationship between the state's obligation to facilitate public participation and the public's exercise of the right to participate. These are two distinct constitutional responsibilities. and the law does not conflate them. The constitutional obligation that falls upon Parliament and upon all state organs charged with facilitating public participation is an obligation of facilitation, not an obligation of outcome. Parliament is constitutionally required to provide adequate notice, accessible channels, sufficient information, and a genuine opportunity for the public to engage. That obligation, once discharged, exhausts the constitutional duty of the facilitating organ. At least that is our understanding of the Supreme Court's pronouncement in Cabinet Secretary for National Treasury and Planning that, I quote, based on the textual markers herein, Parliament's duty is to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. As is plain from its wording, this provision only imposes a duty to facilitate public participation and involvement in the legislative process, end of quote. We hold the view that what the public chooses to do with the opportunity is a matter of individual and collective civic agency, and that agency belongs to the people and not to Parliament. To hold Parliament responsible for the volume of public participation and to judge the constitutional adequacy of a public participation exercise by the number of citizens who choose to avail themselves of it would be to conflate the duty to provide an opportunity with the duty to compel its uptake. We take the position that a process that was accessible to all but availed by a few is not, by reason of low turnout alone, constitutionally deficient, provided that the low turnout was not the product of inadequate notice, inaccessible venues, suppression of participation, or any other failure on the facilitating organ. This principle finds support in comparative jurisprudence. The Constitutional Court of South Africa in Doctors for Life International case was emphatic that Parliament bears a duty to facilitate public participation and that the standard against which that duty is measured is one of reasonable facilitation. It therefore follows that the adequacy of the exercise ought not to be measured by the number of members of the public who ultimately chose to engage or by whether any particular outcome was achieved. The true measure is whether the state discharged its obligation to create conditions in which meaningful participation was genuinely possible. We are therefore persuaded that the appropriate legal standard against which compliance by the National Assembly must be measured is not one of perfection, but one of reasonable sufficiency in the circumstances. As we have stated, the Constitution does not demand flawless execution of public participation. What it demands is a genuine, accessible, and meaningful opportunity for the public to be heard. Even accepting, as we do, that logistical and operational challenges may have arisen in certain isolated cases, which is not an uncommon occurrence in any large-scale nationally coordinated exercise conducted under time pressure, such localized deficiencies would not invalidate the entire process, as guided by the Supreme Court in the BAT decision. The evidence before this court shows that the door was opened widely, accessibly, and in good faith. Additionally, the fact that His Excellency Gachagua's response to the charges was not availed to the public during the window does not, without more, render the exercise deficient. The purpose of public participation in the impeachment process is substantively and functionally distinct from the adversarial hearing to which the respondent is entitled. The public was called upon to express its views on whether the allegations assessed on their face were of sufficient gravity to warrant a removal of a constitutional office holder. It was not and was never intended to be a mini trial of the charges. The Constitution vests the final decision-making authority in the National Assembly and the Senate, both of which are representative bodies exercising a delegated mandate from the people. These institutions heard, considered, and weighed both the allegations and His Excellency Gachagua's full response before proceeding to vote. On the question of compliance with the court orders of 3rd October 2024, which directed the National Assembly to organize public participation at least at constituency level, we find upon careful evaluation of the evidence placed before us that the National Assembly took demonstrable and timely steps to give effect to those directions. A memo from the Clerk of the National Assembly contained at page 996 of the National Assembly's documents provided as follows. The title of the memo was Collection of Public Views on the Special Motion for Removal from Office by Impeachment of the Deputy President of the Republic of Kenya. And the Clerk of the National Assembly writes, as you are aware, the National Assembly is currently considering a special motion for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya. To facilitate this process, public hearings were scheduled to be held in all 290 constituencies on Friday, October the 4th, 2024 from 8 to 5 p.m. And members of the public were notified to submit their views to the constituency or county. Offices of all members of Parliament of the National Assembly notified to submit their views to the constituency or county offices of all members of Parliament of the National Assembly. By a court order issued on the 3rd of October 2024, the High Court in Kenya sitting at Kerugoya directed that the National Assembly organize similar public hearings closer to the citizens, at least at constituency level, on each constituency in Kenya to enable the constituents of members of Parliament responsible for the impeachment process nationally